Job Street, the block, the granite.
Oh.
Took an arrowhead down there, and I'm glad I did, because I didn't realize Martin Luther King spot the Capitol. Oh, this is mine. Oh, sure. Yeah.
He's got all the phone numbers and stuff, me on the phone, it's like, okay.
Thank you. Did you break the court reporter stuff?
I fixed it.
You fixed it? Okay. Oof. All right. Let me check on a couple other things. All right. Mr. Chambers, is plaintiff side ready for the jury to come in?
Yes, Your Honor.
Anything else we need to talk about?
I believe so.
No, we're good. Mr. Fuller?
Yes, Your Honor, we're ready.
Okay. So we'll bring the jurors in. I don't know that I'm going to engage Ms. Anter at this point, maybe towards the end of the day, see what she's learned. But I will give them preliminary instructions and I'll swear them in, then give them preliminary instructions, and then we'll turn to openings, unless you all have something else we need to cover. Seeing nothing, let's bring them in, please.
All rise for the jury. Jury present in California.
Thank you, Deputy Gordon. Everyone else can be seated. Hello again. We are ready to get started with the trial of this case. I need to give you some preliminary instructions before we get started, as well as to administer the jury oath to you all. Then we'll get going. Couple of housekeeping matters. First, there are no assigned seats, so as you come on in, you should feel free to sit wherever you wish. I encourage you to move around a bit. I don't mean in the middle of a proceeding, but between breaks. You literally get a different perspective on the trial if you're seated closer to the witness and further from the witness, way in the back, up front. Sit where you're comfortable, but don't act like you own a particular seat. You just take the seat as you come on in. We will stop at any point any one of you needs to stop. There'll be regular breaks. I sort of keep track. Deputy Gordon will remind me, hey, we need to take a break. The lawyers may ask for one. But if we've hit a point where you are losing your ability to stay focused and are feeling sleepy, let me know and we can stop. It doesn't need to be a long break. It may just be, I got to go in there, get a thing of water, walk down the hallway. There's not a rewind button. Witnesses are testifying and you will not get their testimony in a transcript during your deliberation. So you need to rely on your recollection of what happened here in court as you're deliberating. During the trial, the lawyers are only permitted to interact with you and speak with you here in court. You may bump into them in the hallway and you may have a real innocent question like, which way is the restroom? And they're going to act like you have COVID-20, something new and different and scary, because you can imagine if Mr. Rabai's lawyers are walking down the hall and they see you yucking it up with Mr. Hamade's lawyers, they're going to think, wait a minute, what are they talking about? The answer is probably something completely harmless, like the restroom is this way. But the lawyers need to keep their distance from you outside the confines of the courtroom. We will go till about 5 today. I will take your pulse as we approach. I'll also see where we are with a particular witness. And if the lawyer seems like he's good at managing time and says, I only need 20 more minutes, and that would take us till 5:10, and you all can stay till 5:10, a lot better to finish with a natural break than mid-sentence for someone. But the plan for today will be to go till about 5. When we wrap up today, I'll talk about how the next few days will go. With that, I need you all to stand and raise your right hand for your second oath of the day. This is your juror oath. Do you swear or affirm that you shall fairly try this case and provide a true verdict according to the law that I give you and the opinion that you form concerning the evidence, and you'll do this to the best of your skill and knowledge without favor or affection to either side? Please say yes if you so swear and affirm. Yes. Does anyone not so swear or affirm? No? All right. Thank you. So you all are about to hear the case of Ali Hamade versus Noor Rabai, Mila Naya Investments, and Rabai Investments. Before that starts, I need to talk to you a little bit about what to expect during a trial, not meaning the evidence will be this or that, but structurally what to expect. Your role, my role, the lawyer's role. My recollection from your answers is that most of you have not served on a jury before. And so your sense of what this is going to be like is based on Law and Order or a movie or something, which is interesting and keeps eyeballs, but not realistic. It's not going to happen that someone's going to bust through that door and come in and say, I did it. I killed the Pope. There's no dead Pope in this trial. It's going to come through witnesses. It's going to be a lot of documents. And we're going to talk about how it's all going to flow. You all have notepads. You should feel free to take notes if you want to take notes. Notes are not required, but remember what I said earlier, that while this is all being recorded and ultimately a transcript will be made, there will not be transcripts available for you during your deliberations. And so you will be deciding based on what you recall. Some people will have it all up here in their head. Others will take notes. Nothing wrong with doing that. If you are taking notes, please don't try to write everything down. You're not able to do that. And if you are heading in that direction, you aren't going to be looking at the witnesses enough. Part of your role, and I'll talk about this in a moment, is to determine the credibility or believability of the witnesses. And one way that humans do that is watch how they react. And it may be when one lawyer is asking questions of a witness, the witness is making eye contact with you all and is free and easy and breezy. And the moment the questions come from the other side, the sweat starts to form on the brow and the person turns away or acts in a very different way, all of which you'll miss if your head is buried in your notepad trying to get down word for word what's written. Your notes are to remain private until your deliberations begin. When you are deliberating, you're free to say, look, I wrote this down, I drew this picture. When the trial is done, we will collect your notes and shred them. They're not made part of the record. So if you're writing down, judge is a jerk, that's okay. I will never see that. It won't go in the docket. It will be shredded. They are for you to remember as best you can what was going on in court. In civil cases like this, the plaintiff has the burden of proving his case. He must prove his case by what is known as a preponderance of the evidence. Now, if this were a case where the only side bringing claims was Mr. Hamade's, then I would tell you he's got this burden of proof by preponderance. but there's a counterclaim. So Mr. Rabai is saying, well, wait a minute, actually, I think Mr. Hamade did something. He has that same burden to prove his counterclaim by a preponderance of the evidence. And what that means is literally superiority in weight. And it brings us to that classic image of the scales of justice, the greater weight of the evidence upon the issues involved. To be a preponderance, the evidence must tilt those scales some perceptible way in the direction of the person making the argument. So if the scales are exactly balanced after you hear everything, the person who's saying, wait, I should win, doesn't win. Tie goes to the opponent. But if you hear all the evidence and you lay it down and the scales perceptibly move in your mind in favor of the claims Mr. Hamade is bringing, he's proven his case. It's not beyond a reasonable doubt. It's not 80% movement in the scales. If the scales, as to Mr. Hamade's claim, are tilting perceptibly in his direction, he is entitled to some form of recovery. And you decide what that is. And the same is true for Mr. Rabai. He has brought some counterclaims. He needs to convince you that the scales tilt in his direction. Obviously, if on Mr. Hamade's claims, the scales tilt in Mr. Rabai's direction, Mr. Hamade hasn't proven his claims and he doesn't collect. The basic structure of the trial is that in just a moment, you will hear opening statements from both sides. Lawyers for both sides will get up one at a time, and they will give you a forecast or a preview of what they think the evidence will show. And I think you'll hear that phrase a lot. The evidence will show. The evidence will show. They don't know for sure because the witnesses haven't testified yet, but they've done their homework and they've got a pretty good feel for what you'll see and what you will hear. It's not evidence. If a lawyer stands up and says, you're going to hear that this guy took $1 million out of someone else's bank account, that doesn't mean that ever happened. It doesn't mean there's even $1 million involved in this case. That's the lawyer's forecast, not evidence. Once the openings are done, then I will turn to Mr. Hamade's lawyers and say, call your first witness. And they're going to call one of three people because we've got three witnesses in this case. That person will begin testifying, and when he or she answers the first question, that's the first bit of evidence you receive. Evidence is going to come to you in two forms: the testimony of a witness, someone who's under oath, or a document that's admitted. So you've got the oral testimony and records, documents. That's going to be your evidence. And throughout the plaintiff's case, there'll be people answering questions, and there'll be documents that are entered as they build their case. At some point, I'll say, call your next witness, and plaintiff will say, we rest. They're done. They will have presented their case. And I'll turn to Mr. Rabai's lawyers and say, do you have any witnesses you want to put up? They don't have to, but if they want to try to prove their counterclaims, then they're going to put evidence in some way. That could come during their examination of witnesses that plaintiff called, but there is a burden on the defense in this case because they have a counterclaim as well. When all the evidence is closed, both sides have said we rest, then the lawyers get in front of you again for what we call summation or closing argument. This is when the lawyers are going to try to persuade you to decide the case in their favor. They're going to say, here's why you should give this relief to my client. And you should feel free to be persuaded, but remember that nothing the lawyers say is evidence. They are persuasive, but they are not the facts. And so if a lawyer looks you in the eye and says, so-and-so said the sky was blue, you know, remember it was cloudy that day. You decide whether the sky was cloudy or whether the sky was, because the sky's always blue, but were there clouds out or were there no clouds out? You decide that and not what the lawyers say. But you're free to be persuaded by what they say. When the lawyers are done with their closings, I will give you more law that you must apply to the facts as you find them to be. During trial, the lawyers may object to things. It'll be like you saw on TV. Objection, hearsay, whatever their objection is. I need to rule on those objections. If I sustain an objection, that means I am agreeing with the objection and whatever was happening has to stop and the lawyer needs to move in a different direction. If I overrule the objection, then whatever question was asked remains on the table and the witness may answer it. You should consider only the evidence that is admitted during the course of the trial. If at some point there's something that gets in, there's an objection, and I say, oh, you're right, that shouldn't have come in, I'm going to tell you all to disregard it. And you need to do that. If you wrote it down, cross it out. And if you're deliberating and someone says, hey, remember when that guy said that there were 3 cars on the street and not 2? And you remember, yeah, but the judge said we have to disregard that. You actually need to disregard it. This may seem like a fake thought experiment, but I don't want you to worry. If what you hear that then is objected to and I exclude is fundamental to the case such that you can't unring that bell, then you're going to hear what's called a motion, and someone's going to move for a mistrial because something will have been presented to you all that was so far beyond what you could reasonably set aside. It's not fair to ask you to do that. We have to do the trial all over again. Not with you, but with other jurors. I don't think this is the kind of case where there's going to be much risk of that. A whole lot of it has to do with financial records, and those are in or they're not in. So I don't think there's much of a risk of accidental disclosure of extremely prejudicial, inadmissible evidence. But if I tell you to disregard it, please do so. At no point in any of my rulings on motions or objections should you interpret that as me taking a position on who's doing well, who's got a stronger case, which side is winning, or on the credibility of a witness. That's not my role. I never intend to do that. I'm simply applying the rules of evidence to the objections as they come up. If I sustain an objection, it just means it was a legally valid objection. And if I overrule it, it wasn't a legally valid objection, and we move on. Your job is to determine the facts in this case based on the evidence you receive. Again, witness testimony and documents that are admitted. All the documents that are admitted, even though you may only see them on a screen while they're being presented, they'll be with you to review. So don't worry if they go to page 17 and you're trying to figure out which was that. There'll be hard copies made available for you to look at during your deliberations. You, as fact finders, will necessarily be deciding the credibility of witnesses. You decide which witnesses to believe and which not to believe, if there are any that you find to be incredible or not believable. In determining credibility, you're free to consider all of the evidence you've already received, as well as the manner in which the witness testifies, the witness's interest or lack of interest in the outcome of the case, and the means or opportunity that the witness had for knowing the things she's talking about. You are free to believe or disbelieve all, some, or none of a witness's testimony. You decide what is worthy of belief and what is not. You may, as you hear the evidence and receive the evidence in this case, determine that there are conflicts in the evidence. Things aren't adding up. One person says it was heavy, another person says it was light. If you do find conflicts in the evidence, you should try to reconcile them as if everyone who's talking to you is speaking the truth. Very often, one person will see and process the very same incident very differently than someone else who saw the same situation. It doesn't mean that someone is being untruthful. It may mean that their recollection is different, their recollection is faulty, or they simply view it in a different way. If, however, you find that some parts of the evidence are in such conflict as to make it impossible for you to reconcile them, you must believe the evidence that seems most reasonable, probable, and truthful to you. I mentioned this before you had your mini lunch break, but during trial, you'll be permitted to ask questions of your own. You'll see 3 stacks of note cards on that little shelf in front of a few of the jurors in the front row. Those are for you. Please write your questions legibly on one side of the card only. You can write more than one question per side of card. You can write them down in the middle of the witness's testimony, but I'll also, when the witness is done testifying, give you a chance to write down more if you hadn't been writing them down. Should there be any juror questions when a witness is done with his or her testimony, Deputy Cosby will collect them, get them to me. I'll review them, and if appropriate, share them with the lawyers, and then I'll ask the questions. So you don't need to put your name on there. You don't need to worry about, I'm not good as a public speaker. You just need to be legible in what you write down. And then if it's a legally valid question, I'll ask it of the witness. You should draw no conclusions from the fact that some of your questions are asked and some of them are not. It may be that someone else asked almost the same question and we're asking that version. It may be that your question asked for something that's not admissible in this trial, and you didn't know that, there's nothing wrong with writing it down. If it's not a legally permissible question, I cannot ask it. And questions are not evidence. You're going to have lawyers in this case, especially on cross-examination, who ask questions that sound almost like it's testimony. Isn't it true that on this day, at this time, this happened? And if the witness says yes, then there's evidence that all those things happened. But if the witness says no, there's no evidence that anything happened. And same with your questions. The fact that you came up with it and asked it, if there is no answer to it, doesn't make it evidence. All right. I'm going to say this again, and you're going to hear it repeatedly throughout the trial. You must limit your consideration of evidence to what is presented here in court. No outside research. Don't go home when you're done and say, it's an interesting trial. It involves real estate. Honey, do you know anything about real estate partnerships? Maybe, but unless you plan on calling that person as a witness, which you don't get to do, you don't get to call witnesses, so that both sides could also ask questions of the witness, you can't get any evidence from someone else in your life, only the witnesses. And no field trips. You may hear addresses during the course of the trial like, wait, that's like 5 blocks from my house. I'm just going to roll by and see what it looks like. Don't do that. If it's important to see what the property looks like, and I don't know that it's this kind of case, then there'll be pictures from the lawyers. Or you will write a question. Are there pictures of this property? And if there are, then we'll get you those pictures. But you don't get onto Google Maps or get into your car and check things out. I would be positively flabbergasted if there was any media coverage of this case, but in the off chance you're driving home and on V104, hey, hot new trial in front of Judge McBurney, change the station and listen to something else, because you get a reporter spin on what this is about. And the reporter may be right, may be wrong. The trial is over to get that kind of replay. Last thing, until the evidence is closed and you've received the law that I need to give you at the end of the trial, you actually can't talk about the case amongst your own group as well. There's no early deliberations. You after one witness, hey, what do you guys think? How many think this? Talk about anything else. That's a broad universe, anything else, but don't talk about the case. Wait until you've heard all the evidence, and most of all, wait until you hear what the law is, because you may think this is an easy one until you learn, plaintiff had to prove 3 things, and they never proved number 3. And so there can be no recovery because there was 0 evidence of element number 3. And you won't have that law until the very end. And there's a reason for that. So you're not creating a checklist and saying, great, I've decided the case. And you shut down after witness 1, because maybe witness 2 completely undercuts witness 1, but you weren't listening. So no outside research. Don't talk about the case amongst your number or people outside your group until it's over. None of this is confidential, however. When the trial is over, if you want to compose an aria or write a book or do whatever, that's fine. You will be able to talk about your service with anyone and everyone, should you choose to do so, but not until we're done with the trial. And that, ladies and gentlemen, concludes my initial comments to you. I'm going to turn to counsel for plaintiff to see if either is going to present an opening statement.
I am.
When you're ready, Mr. Chambers.
Thank you, Your Honor. Members of the jury, good afternoon. Select. This is a case about duties of utmost good faith, loyalty, and acting in the best interest of a company and its members. This is a case about Mr. Rabai's breach of those duties in his dealings with Mr. Hamade in connection with Naya Investments LLC. Mr. Hamade and Mr. Rabai first became acquainted in 2011 or 2012 in connection with Mr. Rabai's proposal to marry Mr. Hamade's sister. At that point in time, they did not discuss entering into a business relationship. On a visit to Atlanta in 2016 and 2017, Mr. Hamade saw an opportunity to invest in it and raise the prospect with Mr. Rabai. In June of 2017, Mr. Rabai formed Naya Investments LLC. At that point in time, when he formed it, he named himself as a sole member. Didn't name Mr. Hamade as being a member of that LLC. But they combined their funds beginning in 2017 to purchase property in metropolitan area. Most of this property is in Mount Fair, in Fayette County. Over the next 5 years, they acquired 10 pieces of property. 2 of those were commercial properties, 8 of them were residential. Some of the properties were acquired in the name of Mr. Hamade. Some of the properties were acquired in the name of Mr. Rabai, and some were acquired in the name of Hamade. In January of 2021, they entered into a formal written operating agreement with among other things, the operating agreement entered into recognize that the Illinois formed in June 2017, provided that no member would have the right to demand and receive any distribution from the Illinois in any form other than cash, provided that all funds in the Illinois would be deposited in the name of the bank account, provided that the members of Mr. Hamade and Mr. Rabai would have power to act on behalf, provided that Illinois' assets would be deemed owned by them as an entity, and that the members would have no ownership on their own in such assets or any portion of it. So that the property, once acquired under this umbrella of Illinois, as the companies and not their individual properties. We provided the title to any of the Illinois assets and be held in the name of the Illinois one or more nominees. So they got a title in the name, but it was a meeting on it. One of the truly important provisions of this agreement, it provided that the members may make such capital contributions in such amounts and at such time as the member shall determine. The member shall not be obligated to make any capital contribution. When they formed back in 2017, they did combine funds. But under the 2021 operating agreement, they weren't required to make that. Finally, it provided that the company shall dissolve and its affairs be wound up on the determination by the member that the company shall be dissolved. One of the first properties acquired on the Illinois was warehouse property, 222A Fairburn Industrial Boulevard. You may hear the name and Craigling Drive. It's actually the same street. That was a warehouse property, which they improved it, and Mr. Rabai used it in connection with his other businesses. So quite a few in connection with this food service industry. For several years, his other companies paid rent. 2019, and now it's $10,500. Mr. Rabai controlled the Illinois bank account. He submitted all the information for preparation of the Illinois tax returns, an accountant of his choosing, one which he used to prepare the tax returns of his other companies. And you will excerpts of those tax returns be entered into evidence. We expect them to be entered into evidence. It shows the K1 form, since this was a LLC created as a partnership. Each of the members, what's called a K1. You will see the exact same number of each of their K1 forms in terms of contributions, disbursements, and losses. This was information that Mr. Rabai. In 2019, Mr. Rabai formed his own company Rabai Investments LLC. They're another name is defendants. He engaged in the same type of business that we are now in. Purchasing and renting real estate, purchasing and selling. There's nothing wrong with it. It's under the written operating agreement. They were permitted to enter into similar business. What the 2021 operating agreement is not for is that expenses for Mr. Rabai's other businesses can be paid out of the Neil and I bank account. Or that the Neil and I properties can be commingled with other properties that he owned in his separate. Now, in July of 2021, Mr. Rabai expressed his desire to liquidate the assets and quote unquote, close the books by the end of the year. Mr. Hamade agreed to do so. Over the next 8 months, 6 of the 10 properties were sold. The net proceeds from those sales were divided between the two parties on 50-50 basis. Mr. Rabai, in making these distributions on a 50-50 basis, does not inform Mr. Hamade that, oh, I'm still owed expenses on that. I'm still owed property maintenance fees on that. He never brings that up to Mr. Rabai, rather than go forward. As the end of the 2021 calendar year approaches, Mr. Hamade inquires about liquidating the remaining properties. As the end of April 2022 approaches, he did about liquidating. At this point in time, Mr. Rabai indicates that he would want to keep some of the properties. Worked out a deal with Mr. Hamade regarding the 4 remaining Neil and I properties that hadn't previously been sold, and the net proceeds divided between them. Unknown to Mr. Hamade, so in March of 2022, Mr. Rabai has already transferred ownership of one of the Neil and I properties to its own LLC, Rabai Investments. Unknown to Mr. Hamade is that Mr. Rabai is preparing to transfer the other to Mr. Rabai's own LLC, Rabai Investments LLC. Now, the evidence will show that while Mr. Rabai continued to occupy and use the warehouse property, his last payment of rent is December 2021. He remains occupying that space. This day. He uses it for his other businesses. And according to one of his own excerpts for Excel spreadsheets, he hadn't paid rent for 2022, 2023, 2024, portions of 2025. In April of 2023, Mr. Rabai stops communicating with Mr. John. In June of 2023, the Georgia Secretary of State's office sends a notice of intent to administratively dissolve Neil and I investments to the file obtaining registration with the Georgia Secretary of State's office. Mr. Rabai does not inform this. On that September 8th of 2023, Georgia Secretary of State, in fact, dissolves Neil and I investments. Mr. Hamade, Mr. Rabai does not inform Mr. Hamade of this fact. In September of 2023, Mr. Hamade receives the 2022 tax return for Neil and I investments. It shows that it is the final return. Shows that the company has no assets, that the members have no capital accounts, shows that there were no liabilities of the company, and in fact that Neil and I has ceased to exist. The evidence will show that Mr. Rabai transferred all 4 of those remaining Neil and I properties to first to Rabai Investments LLC, And then later transfer them to yet other LLCs. Rabai Investment Holdings One, warehouse property has transferred debt. Rabai Investment Holdings Two, the three remaining residential property. The evidence will show that Mr. Rabai mingled these dealing on their properties. The properties he owned outside of them. He owned Rabai Investments. He got refinancing. Because refinancings were not discussed with Mr. Hamade and served to increase the debt. The evidence will show that Mr. Hamade using him on a bank account, paper items totally unrelated to Mr. Hamade and the Illinois. The evidence will show that Mr. Hamade failed to inform Mr. Hamade of any of these actions. Mr. Hamade has no interest in Rabai Investments LLC, Rabai Investment Holdings LLC 1, Rabai Investment Holdings LLC 2. He has no say-so in connection with any of these LLCs to which Mr. Hamade transferred the money. There will be evidence presented showing that the Illinois properties Mr. Rabai transferred to himself for his own use at fair market value of $2 million in the summer of 2024. Now, the claims that Mr. Hamade making what's called 4 accounts, each separately named upon his nexus account. You will be concerned before you. The first one is a claim for breach of the offer. Number 1 pages. Let's count 2 of them. Under that account, Mr. Hamade seeks damages that may be found in the foreclosure. He also seeks his attorneys. Under count 3 of the complaint, that is the account for breach of fiduciary duty. Those are the duties that the company was and acting in the best interest of members of the company. That account also names Rabai Investments LLC for aiding and abetting in the breach of Mr. Rabai's breach of his fiduciary duties. Under that count, Mr. Hamade also seeks damages. He also seeks punitive damages, which the jury may be authorized where circumstances are such that you determine to penalize, punish, and deter the defendant in like actions. Under count 3, the complaints also seeking what's called constructive trust. And that is the property Mr. Rabai is holding, is formally needed by and someone else that has an interest in it. That is a remedy that the judge fashions that you determine whether it's a remedy that should be taken. Now, for the complaint, Mr. Hamade, that is just adding the funds used. Mr. Rabi's other businesses will ask that you all enter recorded or any damages be shown because you're not in the now, the defense filed what's called a counter space, judge. In their claim, the defendants claim that Mr. Hamade owes them. The main defendants left the oath on Mr. Hamade appear to be those in some property management companies. And Mr. Rabai executed on behalf of Mr. Hamade to himself. And informing Mr. Hamade of the existence appear to be based on expenses and mortgage payments incurred with the 4 Mulanaya properties after Mr. Rabai transferred. After Mr. Rabai expressed his desire to liquidate the assets. After Mr. Hamade agreed to end the relationship. And after Mr. Rabai transferred his property to his own control. Then it's fair to assert that somehow Mr. Hamade remains bound in some form of partnership with Mr. Rabai after Mio and I was dissolved in the states. After Mr. Rabai had that final tax return. And after Mr. Rabai ceased communicating with Mr. Hamade in April 2023. And this is even though Mr. Hamade never agreed to enter into any relationship with Mr. Rabai other than through the Illinois business. The Hamade, Mr. Hamade denies that he's indebted to any debtor in this case for any amount whatsoever. This case is about the duties of utmost duty, loyalty, and acting in the best interest of a company and its members. We submit that the evidence in this case will demonstrate the breach of those duties by Mr. Rabai and his dealings with Mr. Rabai. And as Mr. Hamade is entitled to it, for the significant. Thank you for your attention.
Thank you, Mr. Chambers. Mr. Fuller?
The local rule of sequestration, I don't know if any witnesses shown up.
Okay, well, Ms. Dyke is the only witness, so if she's not here, other than the parties, so.
Yeah.
All right, we're good.
Yeah, go ahead and share screen now. Let's go over these properties. Always more to a story than what you hear on one person. Yes, they bought 10 properties together, and we'll go over these. And we don't disagree that the man from California is still the owner of those 4 properties. Nor has tried to sell. He's had rehab. Can you show it?
Well, I'm supposed to be doing it.
So you're in, meaning I see you on Zoom.
Oh, hold on. There we go.
I just didn't, I needed to hit share, that was it.
It's a good button.
There we go. All right, well, these are the 10 properties. And they were buying these, they weren't really making any money off of them. You buy them, you have losses, you use them when you tax return, but you hold them and you sell them, and that's when you make the fund. They sold the second cycle. But if you notice, this property, it was in Mr. Robbie's name. 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 This property, they had to put it in Peter Restaurant Entity, which is a Peter Restaurant Company, because they had to, get financed. They had to get an SBA loan to take care of that. What would happen in the future? This property was in Mr. Robbie's name. Ali Hamade only had one. He had 2 properties that he acquired with Mr. Robbie doing. As you notice, we don't have Neil and I in here. These guys treated it like a partnership. You'll hear about the law later. And nobody is saying that Mr. Hamade is not entitled to something if these other 4 properties get sold. Let's take a look at the next page, Jacob. Jason, not Jacob. That's my son's name. These properties were also, that's the total net proceeds. And they split it 50-50. Now, when it came time to try to sell the other properties, well, quite honestly, we got a brother-in-law and a brother. They were the family dispute. They went off. Simple as that. Mr. Robbie has continued to handle the properties. He continues to maintain them. They're saying that his company doesn't pay rent. Well, who pays the mortgage? Who pays the taxes? Who pays the maintenance? I mean, all of it. It's all accounted for. We've got everything accounted for. He's kept a good accounting on all of these properties the entire time and still has a good accounting. We don't disagree that they're on 50/50. But in 2022, Mr. Robbie couldn't sell the other 4 properties. Warehouse, which is what's called 222A, is what it is. That had to have some rehab, had to have some stuff. He refinanced them, but to do it to the SBA, he had to use a different company, not in the individual name. So that's why they're in the name of Robbie Investments. If you can see, that's the way these guys are doing this all along. We don't disagree. But until the properties are sold, he's not entitled to anything. Let's go to the next documentation. This is what we refer to as our county. But I want to explain this to you a little bit. They were a little loosey-goosey with their money. They would have money from personal accounts going to Mila. They'd have Mila going to different places. They both did this. Mr. Hamade wanted to give up cash advance from one of his buddies in Lebanon. So they did. That money is on that. Mr. Hamade wanted a home. So they got it. That money was on that. Yes, there's a claim for maintenance fees. Let me explain something to you. We have 10 properties. This is going over for 10 years. The only person dealing with these properties was Newell Riley. The only person dealing with the tenants was Newell Riley. The only person dealing with the repairs was Newell Riley. The only person paying the bills was Newell Riley. And so he had an agreement with the company that he would get 5% as an management. Tenant had to be kicked out, he had to deal with it. New tenant coming in, he had to deal with it. Repairs had to be made, he had to deal with it. Need to sell a house, he had to deal with it. So yes, it's our management fees that he's had to be paid back. Since the 6 properties were sold, we have losses of about $256,000. So who's paying that? That's right. Taxes have to be paid. Who's paying that? Mr. Ryder. Also gave Mr. Hamade a $10,000 check to help with the franchise of a PETA franchise that he never got into, never operated. That money has got to be paid back. His loan closes because these properties needed to be refinanced. They were on a high interest rate. They went down in 2022. So we have loan closing and financial expense of $38,000. So the total of $817,736.72 that is owed back. The way that works is Mila now, whether it's an LLC or partnership, actually owes the money to the person that pays it. Okay? So that money was funded, it's got to come back. If we sell the properties, that money has to be recouped. That's what this is all about. I can't sit here and tell you that Mr. Hamade has got to pay capital contributions. Nobody's required to do that. But somebody had to front the money and pay it. So when these 4 properties are sold, that money's got to go back to Newell Riley. That's where we are. We're in a situation where the lawsuit's been filed too soon. The properties have been sold. He's not trying to force the court to sell the properties. He just said, oh, I'm done. You got these 4 properties. Yeah, they're in Robbie Investments thing. Totally agree. But that's the only way they could have refinanced. They haven't put up for sale, didn't sell. One of them got to have a roof. One of them got to have all kinds of repairs to it. And it's going to take some time. If he wants these properties sold, fine. But he doesn't. He's sitting here suing for a whole bunch of money. And the accounting you'll see, we've got good detail records. You'll see Mr. Robbie's kept track of everything. Everything. And he's got very good records. I've got 175 exhibits over here. Now, don't worry. I'm going to try not to give them all to you. I'm going to avoid it overdating you as much as possible. But that's we have the receipts, which is important. So, just a couple things about trials. The judge gave you an outline. It's kind of like, you can go watch a law show or a podcast. Listen, you know, you might see an hour's worth of testimony is all you need. However, to create that TV show, it takes about a week or 2 weeks. So you have to sit behind the scenes. There's a lot of things we have to do that are technical. That's going to frustrate you, like when we put in documents. You have to go through this process and this process. So don't blame it on our clients. It's just the system can seem slow sometimes. Now, we've agreed to a lot of things, so we can move this case along, so you don't have to stay here too long. You know, I've agreed to let them have their appraisers and just put the appraisal with the evidence instead of having guys to testify. That's fine. You know, we've agreed to a lot, so we can make y'all kind of get to the key to this case. So, they don't want to be here, neither do I, but we have to. And we're going to try to give you a very clean, fair look at both sides. Thank you.
Thank you, Mr. Fuller. I'm happy to be here. So, call your first witness.
Take that off.
Your Honor, we'll call, Mr. Hamade.
Mr. Hamade, if you come on up to the witness stand, please. Deputy Gordon will swear you in. We could, here, I'll unshare.
What city you face me or right hand? You swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth. Yes. Lord, I seek. Can you state and spell the name of the record?
Ali Hamade, Alihamade.
Your Honor, I hate to interrupt, but I didn't get their exhibit list.
It was emailed to you.
Send them on.
I can give you.
I got your exhibits.
Yeah, they did.
I have the exhibits. I don't have the list. So I can keep track.
I only have one copy. But I'll get a copy made of it, so it'll work its way to you.
Here it is.
Never mind.
You got one? Great.
Okay, Mr. Hamade, what was your relationship with Milanai Investments?
Partnership,
And who were the partners in that partnership?
Noor Rabai and myself.
When was Milanaya organized?
Approximately summer of 2017.
And can you describe the business of Milanaya for us?
Related to real estate purchase, acquiring properties, commercial, residential, and renting them out.
What's the significance of the name?
The name of the company?
Yes.
Noor decided to pick both of his daughters' names and put it into the company.
Got it. So Mr. Rabai has a daughter, Mila, and a daughter, Naya.
Correct, yes.
Who would be your, what then, nieces?
Says yes.
Are you and Mr. Rabbi the only partners in that partnership?
Yes.
How did you become acquainted with Mr. Rabbi?
2011, approximately 2011, we made a trip, my sister, myself, and my brother, to Atlanta to do some business. And then in the process, we were dining or having a late lunch in a restaurant that is owned by Mr. Rabbi's aunt. And he happened to pop in, so this is how we wind up meeting him. And then moving forward, he developed a relationship with my sister, and he became my brother-in-law.
When did you begin discussing a business relationship with Mr. Rabbi?
This was somewhere 2017. Initially, the conversation started probably 2016. But we got in business 2017, I would say.
Did you or Mr. Rabbi form Milanaya Investments and file the articles of organization, Secretary of State?
Noor did, yes.
You mean Mr. Rabbi?
Mr. Rabai, yes.
Do you recall when those articles were filed?
Not quite, not at this moment.
When those articles were filed, did you and Mr. Rabbi have an agreement on how the company would be operated?
In regards to operation,
Not a written agreement, but any kind of agreement, Mr. Rabbi.
it was just the generic agreement that you would get out of the system when you register a company, an LLC. Does this answer your question?
What I'm getting at is how did you what did you and Mr. Rabbi agree to on how the company would be operated, how profits would be split, how property would be
50-50,
owned?
50-50.
Later, did you and Mr. Rabbi enter into a written limited, excuse me, liability company operating agreement?
Oh, I'm sorry, I couldn't hear it.
Later, did you all enter into a written
Yes,
liability
we did.
company
Yes, we
operating
did.
agreement? Hand this to you, or you just want to?
I've got them, I've got them, I've
Okay.
got them. Just
May I approach your honor?
obviously say which one it is.
Yes, so both sides have continuing authority to approach witnesses. My preference is if you've got 14 exhibits you're going to share with a witness, bring all 14 at once. So it's not a back and forth, back and forth. And then you can just direct the witness's attention to the specific exhibit you want each time.
We'll be doing through your honor. Three.
Okay.
Hey, Mr. Rabbi, look at,
This is
exhibit
Mr.
one.
Hamade.
Sorry. Please look at, exhibit one.
Yes,
Is that the operating agreement of Mila and I, which sets forth you and Mr. Rabbi's agreement on how the company would be operated?
yes,
Does the agreement provide that title to any of the company's assets can be held in the name of the company, one or more nominees, or in a street name as the members may determine?
I don't understand the question.
Does the agreement provide that the assets of the company don't have to be titled in the names of the members?
Oh, yes,
So they can be titled in y'all's individual names or some other name?
correct.
Did in fact the company have assets, specifically real estate, that was held in the name of the individual members, you and Mr. Rabbi?
Yes, the company did have in my name and Mr. Rabai's name.
Does the operating agreement provide that the members shall not be obligated to make any capital contributions?
Yes,
Does the agreement provide that both you and Mr. Rabbi have the power to act for or on behalf of the company?
yes.
Do you want to tender the exhibit before you ask him a whole bunch more about it?
Yes, Your Honor. I'll tender that as exhibit one.
Okay, any objection to plaintiff's one?
No objection.
Admitted.
Does the agreement provide that the company's assets shall be deemed owned by the company as an entity and that the members shall have no ownership interest in the assets or any portion thereof?
Yes,
Who kept the books and financial records of the company?
Noor Rabbi did.
Who collected the rents from the property and paid the expenses on behalf of the company?
Noor Rabbi.
How many properties did the company ultimately purchase?
10 properties.
Were these properties residential properties or commercial properties?
We had 8 residential and 2 commercial.
Did Mr. Rabbi or one of his businesses become a tenant of one of the properties?
Would you please repeat?
Did Mr. Rabbi or one of his other businesses become a tenant of one of the properties?
Yes,
Which property was that?
222A Fairburn.
Can you describe that property and tell us how it was used by Mr. Rabbi's other business?
This property was acquired 2017, and it was created into a commissary. And it's been used for the last, since then, it's been used for that purpose. And also a couple other companies that he added to the, as a tenant to the company.
Did Mr. Rabbi pay rent to the company for the use of that property?
That was the agreement, so yes.
Were any of these 10 properties eventually sold?
Yes, 6 of them were sold.
Do you recall when they were sold?
I would estimate 2020, 21, some 2021, right around the time that Mr. Rabai decided that he wanted to liquidate, and some in 2022.
Why did you and Mr. Rabbi decide to sell the properties?
It came about a little disagreement, and actually it wasn't a disagreement. It was some sort of we were trying to reconcile some numbers, and there was a little bit of sorry, just give me 1 second. So what happened, we were doing some reconciliation, and there was a figure that it wasn't accurate, that Mr. Rabai had on a spreadsheet. And this is when basically he told me, I'm going to forward this spreadsheet to you, look it through and see what happens with it. I took it. Month later, I hired an accountant to look through it since I couldn't do it myself. And then the minute Mr. Rabbi found out that basically I handed it to somebody to look through it, he was like, okay, let's address these questions right now, right here. I said, no, I'll fly in and we could sit and discuss it. He was like, no, I want to do it right now. So we did. An hour or two later, I received an email basically telling me, you know what, I want to liquidate everything. And I said, come on, it's not worth all this trouble. Let's talk about it and figure out what the situation is. From there on, I agreed to him, and this is how he wind up. He mentioned in his communication that, hey, I want to get out of this by the end of this year. And I said, if this is what makes you happy, let's just go ahead and do this.
When those properties were sold, did you get 50% of the net proceeds from the sale?
I did receive my share. Whether it's 50 or not, I'm not quite sure. I can't answer that. But practically, based on my trust to Noor, he told me this is the money. I took the money. I did not have any closing statements. I did not have any supporting.
My question was not whether you got any money,
Yes.
but did you get half the money from those sales?
Yes, yes.
Take a look at what I've labeled Plaintiff's Exhibit 3. Have you seen that document before?
This is U.S. return document. Certainly, it's partial. Yes.
Is that part of Milanaya's 2021 income tax return?
Yes,
Have you seen this document before?
I have. Yes.
Who prepared this document?
An accounting firm that is It's called Barney's CPA.
Did you have, who retained those accountants?
Mr. Rabai.
Did you have any contact with those accountants?
Very minimum, practically only if I needed to request my K1s, my Mila Naya's income return, so I could get my K1, so I could submit my taxes.
Did you provide any of the information to them concerning the information on this tax return?
No.
Your Honor, I'd like to tender this exhibit as Exhibit 3.
No objection.
So your exhibit list has 2 and 3, just two different years of tax.
3, I'm a little out of order.
Okay, you're working with 3, which is the 2021 return.
That's correct.
Okay, that's admitted.
Please look at Form 8825, which is the second and third page of that exhibit.
Are we still Exhibit 3?
Yes.
Yes.
I'm sorry, what page is that?
It's the second and third pages. It's Form 8825.
Okay.
Is that an accurate list of all the properties that were subject to your and Mr. Rabbi's agreement concerning the Mila Nila Investment LLC?
Yeah, yes, 10 properties.
Were all of these properties owned in the name of Mila Nila Investments?
No.
Did you and Mr. Rabbi agree? I'm sorry. Strike that. Which of these properties were titled in Mr. Rabbi's name?
I could point out the things that basically I know that they're tied to the Mila Naya and the properties that are tied to mine, and then we could exclude these properties, and then possibly the remaining would be under Mr. Rabbi's name.
Please look at what is the first page of that exhibit?
Which exhibit?
I'm sorry,
Exhibit 3?
Are we still on exhibit 3?
we're still on exhibit. Yes, Your Honor, we're still on exhibit 3.
Okay.
What was the question?
I'm sorry, strike that question. Did Mr. Please look at the 5th page of exhibit 3. That's your Form K1.
Okay, yes, I see it.
What does it show as your share of the profits that year?
50%.
What does it show as your share of the losses for that year?
50% as well.
What does it show as your share of the net income or loss? Let's go down a little lower on the page.
Capital, okay, so
Keep going.
I see ending capital account. Is that what it is?
No, go down a couple of lines. It'll say current year net income or loss.
I don't see it. So if somebody could point
You
it out
looking
to me.
at your K1?
Yes, I am at the
May I
K1.
approach the witness?
You may.
Over on this side we're talking about. This one, okay. Current year net income, sorry about this, 165,157.
And go down a little bit farther, and what does it show that you received as withdrawals or distributions in 2021?
255,439.
Did you receive $255,439 in withdrawals or distributions in 2021?
I don't know. I don't think so, actually.
Did you receive any distributions from Milan?
I did receive distribution, yes.
How much did you receive?
I would say approximately about 207,000.
That 207,000?
Yes.
Take a look at what I've labeled plaintiff's exhibit 2, please. Can you identify that document?
Yes, this is an income return for 2022 for Milanaya.
Have you
The
seen that
partial.
document before?
Yes, I have.
Who prepared this tax return?
Same firm. It's Warren and Barney's CPA.
And those are the same accountants who prepared the
Yes.
2021 tax return?
Yes.
Did you provide any documents or any information or have any communication with these accountants regarding the preparation of the 2022 tax return?
No.
Look at the very first page of that exhibit. Can you tell us what that first page is?
It's a letterhead addressed to letterhead for Milanaya addressed to Noor.
And what does that letter ask Mr. Rabai to do? Look at the very last paragraph.
Do you want me to read it?
Read the very last paragraph, please.
So what exhibit number is this?
2.
2. So it's not in evidence yet. If you want him to read from
Your
it.
Honor, may I tender this as an exhibit?
Sure. Any objection to plaintiffs to admit it?
I could go ahead.
Go ahead and read it.
You must distribute a copy of the 2022 Schedule K1 to each member. If applicable, be sure to give each member a copy of the partner's instructions for Schedule K1.
Did you receive a copy of this tax return in your K1, Mr. Rabai?
No.
How did you get a hold of your K1?
I reached out to the CPA.
That would be the CPAs who prepared this
Yes.
return that were hired by Mr. Rabai.
Yes.
Why did you have to reach out to the CPAs to get this K1 and the tax return?
Since we practically, there's always a delay, and I don't recall what the communication was. It was weakened by then. So basically, I couldn't get it through Noor, and I wind up reaching out to these guys through an email.
Take a look at the second page of the exhibit, which is the first page of Mila Nye's 2022 income tax return.
Second page.
The second page of the exhibit,
Okay.
first page of the return.
Okay. I'm looking at it.
Okay. Take a look at line G, which is just under the name and address block at the top of the return.
Yes.
Okay. Can you read for us what line G instructs?
Check applicable boxes.
Okay, and what box is checked?
Final return.
Take a look at the next page of that exhibit, please. And look at Schedule L.
Okay.
What is Schedule L?
Assets and liabilities, liabilities and capital.
At the end of 2022, what does it show that the company had in total assets?
2,646,000. Is that the number we're talking about?
That's the beginning of the year. Please look at the end of the year.
Oh, and basically zero.
Basically zero?
It is zero.
Hey, please look at the total liabilities and capital. It's line 22. What does this return show the company had in liabilities and capital at the end of the year?
You want the beginning or you want
The end.
The
at
end,
the end of
it's
the year.
$0.
Look at Schedule M2, which is at the bottom of the page. It's titled Analysis of Partners' Capital Accounts.
Okay. I'm sorry, did you ask me something?
Not yet. He's wanting you to look at it.
Oh, I'm looking at it, yes.
So be ready.
What does it show the total distributions to the partners were during that year?
Am I looking at
Look at line 6.
line 6?
Schedule
Okay.
M2.
It shows 152,494.
Did you receive any distributions from Milanaya in 2022?
No, not from Milanaya.
Were there times when Mr. Rabai would send you money? It wouldn't be on a check from Milanaya or a transfer from a Milanaya account to you, but Mr. Rabai would say, I'm making the number up. Here's 50,000. This is your distribution for this year.
Yes.
Take a look at your schedule K1, which is I think it's 3 or 4 pages later.
The form is A1.
K1.
I'm having trouble finding it.
Connor, may I approach?
You don't need to ask anymore. You are free to approach.
I see B1. Oh, K1, sorry. Okay. Thank you.
What does that form show the distributions to you were in 2022? Look at Part 1, Section L.
Negative 41,408.
That's your beginning capital account.
You want the end one?
I want
Ending
your
capital?
withdrawals and distributions.
76,247.
Did you receive $76,247 from Melanaya that year?
No, not to my knowledge. Not to my knowledge.
Who is in charge of handling the day-to-day operations of Melanaya?
Mr. Rabai,
What did that entail?
managing the properties, basically receiving rent, handling the bank account, and if there's any issues with tenants, it would be addressed, as well as just maintaining the portfolio of the company, whatever it entails.
Did you have any agreement with Mr. Rabai that he was entitled to additional compensation or an additional percentage interest in the company for performing these services?
No, we did not agree to that.
Did you discuss with Mr. Rabai that Melanaya hire a management company to take over the management of these rental properties?
I did, yes.
What was his response?
No, I'm okay with it. I could handle it. We don't need to hire a company.
That's what Mr. Rabai told me.
This is, yes. And it happened on more than one occasion.
Did you agree that Melanaya would pay Mr. Rabai a fee for managing these properties?
No,
Did Mr. Rabai inform you that he started paying himself a management fee from Melanaya's bank account?
no,
Did Mr. Rabai inform you that he had started paying himself a management fee from Melanaya's bank account?
no.
When did Mr. Rabai stop communicating with you regarding Melanaya investments?
When did he stop or start?
When did he stop?
Stop. I would take a wild guess. I think it's April of 2020, 2022.
Do you have an interest in Rabai Investment Holdings?
No,
Do you have any interest in Rabai Investments LLC?
no,
Did you ever agree with Mr. Rabai to continue to have any business relationship with him other than through Melanaya Investments?
no.
No further questions, Your Honor.
Mr. Fuller, questions for Mr. Hamade at this time?
Yes.
So I have, Mr. Dakin, that you admitted 1, 2, and 3.
That's correct, Your Honor.
Got it.
Your Honor, do you mind if I grab my bottle of water?
I don't mind. You should go get it. Maybe they'll meet you halfway. He's getting his water.
I'm gonna try not to be repetitive, okay? So you agree that you guys bought 10 properties together, correct?
Yes,
Okay, and you agree 6 of those properties were sold, correct?
I agree, yes.
Yes, and you were paid out of those 6 properties.
Yes,
All right. During this time, you lived in California.
yes,
Okay. And Mr. Robbie handled the day-to-day operations of these properties.
yes,
He dealt with the tenants. He collected rents, correct?
yes,
He handled the evictions.
yes,
He handled mortgage payments.
yes.
Were there mortgage payments on all these properties? Oh, well, this is a bad question. Were there mortgages on all these properties?
Yes,
Okay. And he was paying those mortgages out of the rents.
correct.
And 222A, which is the warehouse, has a mortgage.
Yes.
Are you paying that mortgage?
Could you specify?
Are you paying that mortgage?
When you say you, he personally?
Yes, you personally. Are you paying that mortgage?
Currently, we're talking about?
Yeah.
No.
222A.
No, no,
Are you paying the taxes on that property?
no,
Are you paying for any of the upkeep on that property?
no,
Okay. The 4 houses, the other properties left over are homes, correct?
yes,
I have them listed if we need to, but I don't think we need to right now. Those have mortgages, correct?
yes,
And those mortgages are being paid by Mr. Wright, correct?
yes,
And the maintenance is being paid for by Mr. Wright.
yes,
The taxes are being paid for by Mr. Wright.
yes.
Okay, did you look at his P&Ls that we provided to your attorney to show that there's really no profit on these 4 properties right now? I'm not saying there's not equity, but profit. Did you look at that stuff?
No, I didn't.
Did they give it to you?
I'm sure I have access to it. I just didn't see it.
Okay. During the time that you were in good relations, Mr. Robbie I think y'all had a Google sheet where you were keeping track of the finances,
Yes,
and then you switched it over to an Excel,
correct.
and Mr. Robbie would send you the Excel sheet,
Yes,
and y'all would talk about it, go over
yes,
it, and I think you had one time that you said you disputed something, right?
yes.
And he got on the phone with you and he fixed it, correct?
No, it wasn't fixed, but yes, he got on the phone and
I'm sorry.
go ahead.
Don't mean to interrupt. Do you recall what the dispute was over?
If we're talking about the error that took place,
Yes.
based on his bookkeeping, I do recall this instance. Yes, that was the initial kind of like fallout where it ended up being where we are today. So
Well, do you recall what it was?
yes, well. My understanding of things are a little bit different than what you're suggesting. There wasn't a dispute. There was an error that needs to be addressed, and we need to find out what this error is. At that point, it escalated into he's getting a little upset, and he wound up sending me this message, this communication that I want to basically liquidate and walk away from this by the end of the year. Again, as I repeated earlier, I mentioned to him like, hey, let's discuss it. I'll fly in, we'll talk about it, and we'll figure out what the situation is. And the next thing, he said, no, I want out. You want to buy me, or you want me to buy you, or you want to sell? I said, whatever you think is best. He said, sell. I said, okay, I agree to that.
Did Mr. Robbie guarantee these mortgages?
We both did in different properties. So I've had properties that I had to guarantee the mortgages, and he had properties he had to guarantee the mortgages.
Call which ones you guaranteed?
Yeah, I did Lakemont. One, I can't remember the physical address, but there's two Lakemonts, yes.
Yeah, there's two late bonds. You did you were on
Yes.
those were in your name.
Yes.
correct? And they got sold and you got paid.
Yes.
Okay. That's the only two that were in your name.
Yes.
The others were in Noel Robbie's name.
Yes.
I believe 222A, before all this occurred, had to be in a joint name with one of the companies, didn't it? Like PETA?
No, it was supposed to be, he could have been the guarantor, but when he decided to pull money for the commissary, so he could get access to the build out, this is where I believe he wound up engaging the other company.
Okay. And they required it to be in two different companies.
I don't know the specifics because I am basically fully letting him drive. It's full self-driving. The way he handled things, I just gave him authorization to do whatever he thinks is best.
Okay, you gave him permission to do it, do whatever he thought was best, correct?
In the aspect of in this situation in the warehouse, yes.
Okay. Sometime in 2022, y'all quit talking. Correct?
I would say I did not quit talking. He quit talking.
Well, did you try to call him?
Yes, I did.
How many times?
Several times. I flew twice, one time to Georgia and one time to Miami, and basically nowhere to be found and no response whatsoever.
Did you try to text him?
I texted him, I emailed, and I flew out as well.
Do you have those with you today?
I have these with me. I could provide them if you need to, yes.
I'd like to see where you were texting. All right, there was a family dispute that occurred in 2022, correct?
Not to my knowledge, no.
Do you talk to your sister anymore?
I would pick up the phone and call her right now. She's the one who doesn't want to talk to me, so.
Okay, so there's something going on. We don't need to know why.
Yes.
Okay. All right, do you recall taking $40,000 and sending it to a friend in Lebanon?
No.
You said, well, I'm gonna show proof of this during my case.
Please go ahead.
You don't have a friend in Lebanon, you requested $40,000?
No.
You did get the Hummer though, right?
I did, yes.
Okay, who gave you how did you get the Hummer?
Uh, Neil got it through his brother and shipped it to me, yes.
Okay. Do you know how you paid for it?
He paid for it, yes.
Do you know if it came out of Mila or Noor?
No, it's not from Milo.
Okay. Well, y'all having money going back and forth personally to run these properties?
No, not running the properties.
Well, if you needed to send money to buy properties, send it to Mila.
Yes, I will send it based on where the loan is going to be generated from. If it's to my personal name, then I would have to pay it from my personal bank account. If it's yours, it's the same way.
So
So
a lot of the accounting involved your personal accounts and Mila's accounts.
I couldn't hear you.
A lot of the accounting involved Mila's accounts and your personal accounts.
I wouldn't specify it this way. No, it should be everything related. The initial down payment that goes into the property, it might go from my account or his account, but then moving forward, once the property is acquired, it should be going into Mila and out of Mila as far as the financing, the mortgages, the taxes, and all these things. This is the way we agreed that we're going to work this operation.
I don't mean to interrupt.
Go, please, go ahead.
But you were receiving money from Noor directly.
Could you please specify what do you mean?
You received money from Noor directly.
No,
This is what I asked you about. Sometimes instead of getting a check from Mila Naya Investments, you might, whether it's a check or a wire transfer, I'm not trying to lock you in there, but I thought you had said sometimes I get a payment from Mr. Rabai and not from Mila Naya.
if I could clarify. So the only time I received money, it was the distribution of the properties that they were sold. This is the only time that I have received my share of the property.
But when you received that, was that a check from Milanaya? Was it a bag with a dollar sign on it that Mr. Rabai handed you? Like, how did
it was at times from Milanaya and at times from his account, which I'm not sure which accounts are they, but yes.
Okay, so sometimes Milanaya, sometimes Mr. Rabai, but you've helped me better understand. And this was only after properties were sold.
Exactly, thank you.
Okay.
Did Mr. Robbie tell you that the 4 remaining properties needed to be refinanced?
No,
Right?
no,
Talk to him about it at all?
no.
Okay. You know, rates had dropped by that time.
Rates dropped.
Had dropped.
I don't recall this has been already 4 years, so I
That's
don't.
2022. Okay. So you don't know,
I acquired a property in 2022 and the rates weren't that great. They were in the 5%.
well, did you property for yourself or?
Yeah, in California, yes.
Okay.
Yes.
You got a silent partner in this, don't you?
I do, yes.
And that's your brother.
Yes.
And have you paid him?
No.
Okay. And why not?
It's just happened we have not done the reconciliation, him and I. There's other things involving having to, and I'm being straightforward about this. We have not done it, no.
Okay. You're kind of waiting until you reconcile with Noor.
Well, there are other things that needs to be addressed. There are other transactions that we need to do. So he might owe me after all, so we don't know.
This is your brother we're talking about.
Yes, yes.
And I'm talking about in the Milanaya partnership or LLC, whatever we'll call it. That's what I'm talking about.
Milanaya, yes, he does have half of what I own. Yes.
Yeah, I'm not concerned about your other business.
Yes.
You know, I don't want to get into that. One second, Ron.
Okay.
That's all I got, John.
All right, any redirect? Whoop, you okay? Okay, it's all good. It's like, you can't bust out of here. You can stretch all you want. Yes, sir.
Mr. Hamade, did you receive part of let me strike that. Which of the properties did you pay part of the purchase price for? These are some of the 10 properties that were owned by Milanaya.
I'm sorry, I didn't catch the first part
Okay.
of the question.
Of the properties that Milanaya purchased, did you pay part of the purchase price for those properties? And were those properties in your name?
Yes. There were 2 properties under my name.
What were those properties?
Both of them Lakemont. I guess it's 270 and 300.
Did the money you received from Mr. Rabai, were they the result of the sale of those properties?
Yes.
That's all, Your Honor.
Okay. Any recross?
Oh, no.
No? All right. Mr. Hammond, thank you so much. You can step down, grab your beverage, not the papers. Leave the papers right there. Yep, thank you. Oh, that's right. Thank you for reminding me. Deputy Gordon. It's right here. Hold on one sec. I made a mistake. Jurors, if you have any questions for Mr. Hamade. Now would be the time to write them down on note cards and get them to Deputy Gordon. See if anyone's moving for cards. All right, take a second. Please write legibly one side of the card.
You guys, you can.
Thank you. So, Mr. Hamade, a couple questions. How much is it that you are contending you are owed by Mr. Rabai if you're not quite sure how much you've received from him? What are your, is there some total you think you do, some of which has been paid, or help the jury put a number around things?
It would be an estimation of about $800,000.
Okay. And that's based on what?
Based on it's factoring in the value of the properties minus the mortgages. Part of it also the margins that was left from rent. The rent's been collected for the last since the properties are acquired that they haven't been added, and that should give us. And there's also some sort of a loan that was pulled out on these properties, where it kind of like gave liquidity. And if you add all of this up, it could equate to $800,000.
Okay. And tell the jurors what it was that triggered your realization that there was this disputed amount.
It wasn't, it was done based on calculation, not based on, it's not like, I'm sorry, just ask me one more time.
I'm trying to figure the question out myself.
Yeah.
So there was a point in time when you felt like you realized, wait, I should be due money that I'm not getting. Was there a particular event that caused you to realize, wait, there should be, whether it's monthly payments, annual distributions, or what, was there something that led you to the realization that you weren't getting what you felt was your 50% share?
If I understand the question correctly, I kind of, when things ended up in this kind of situation and we wanted to liquidate, I gave it the time of the day for him to sell and then do the distribution. And then we got to number 7, and 7, 8, 9, 10 got stuck. And then my communication was, I'm being patient, figuring out what's happening, how is it going. Basically, I let it rest for a little bit, just give him the time so he could liquidate these properties. And then at one point, this is where the communication decided to just literally ghost me in every aspect. This is when I felt like, okay, well, since the communication is not going to take place and we're not going to try to remedy this situation and our relationship, then I might have to seek a legal help. I hope that answered whoever is asking this question. So
Got it. Thank you for that. Do those questions lead to any follow-up from you, Mr. Dakin?
No, sir.
Okay. Mr. Fuller?
I just want to be clear. I think what you're trying to say is that you believe you're entitled to half the equity of these remaining properties since they haven't been sold. That's where most of this is coming from, correct?
I'm stuck in 2021. I'm not here today. So yeah, like the properties are owned by Milanaya until the end of 2022, maybe partially in 2023. So yes, I'm in that segment where I feel like this is where we need to go reconcile the books and then pay.
Okay. You want them sold or you won't have the equity?
At this point, I don't have a say on what takes place with these properties. So sold or not sold, this is not an issue I have to address. It's more like this is what we need to settle this situation. So I hope that answers your question.
I'll tell you right now, we'll sell the properties.
All right, but that's not evidence. Lawyers don't testify. Thank you for your time. I had let you go a little early, but you've now covered everything that was asked of you. Thank you. Next witness. Let's figure out who the next witness is first.
Well, Mr. Rabai, for purposes of cross-examination.
Okay, we'll do that after the break. Your third witness is available if we need it, or that would be something we'd have to start tomorrow?
I think we need to start that tomorrow, Your Honor. She's testifying in South Carolina in another case today.
Will she be here first thing tomorrow morning? You're sending the Dakin helicopter?
No, we'll be here tomorrow afternoon. I'm pretty sure it's that.
We'll talk outside the presence of the jury about making sure we're moving forward. All right, ladies and gentlemen, we're going to take our first, it's trial time break. Please don't talk about the case while you're on your break. No outside research. We'll get you back here in about 10 minutes-ish. Two things. One, again, the hallway is yours, although I have two colleagues further down the hall, so don't be yelling down at the end of the hallway, but you can use inside voices and certainly look out the window. And two, I forgot what number 2 was, but you certainly can use the hallway and don't talk about the case while you're back there. I'll remember it when we get back.
All right, observed.
Thanks. You told them the waters are there, so I see people, good. Wait, before you run off, one, I will make all the juror questions an exhibit. They'll be collectively Court's Exhibit 1, because we may reach a point where there's some that are proposed that I don't ask. And as I explained, if I get one that I'm not sure about this one, we'll talk outside so you can see them in advance. These two seem pretty front and center. So you all can start your break in a second. I'm confused. You should just be thinking about the happy answer you're going to have to the question of if Mr. Rabai's testimony ends today, that you elicit, or early tomorrow morning, what it is we're doing while we wait for your only other witness to be here. You don't have to answer right now. I want to make sure you get a break because this is using up your break time.
The order we proposed was to introduce the other three appraisers report. And I think the pre-trial order has a statement to make at the time of the introduction, just that there are witnesses, how you,
Bless you.
the warehouse property at X number of dollars and then three residences at X number.
Right. Why would that take more than about 5 minutes?
It probably won't,
Okay.
but that was, I'm not sure if we're gonna finish with Mr. Rabai today.
Okay. I don't want you to stretch it out just to fill the day, but I heard you say that Ms. Dyke wouldn't be available till tomorrow afternoon. Maybe you can check during the break if she could drive home tonight, and so she could be here tomorrow morning, because it sounds like we'll be ready for her in the AM. Okay. Anything else from plaintiff before we break? From defense?
No, I'm just making sure we're gonna be able to leave our stuff here.
Yes, sir. Courtroom will be locked.
I'm gonna need to come in a little bit early tomorrow.
We'll talk about it when we're done today.
All right.
All right.
To organize my exhibits, so I'm not fumbling.
Hey, intern, do you have any questions?
Not yet.
Not yet? All right.
He's over there, okay.
Good man, he's high. I'm just actually reading almost like I was not. What did I say? There was. The Hamade said that. That's what he wanted to say. Why? There's one point six. Yeah, I can look at that as a hardwood floor guy. I represent, I was still in Slovenia. Still not, I think she is. But the claim center is beautiful. And your other attorney called and said, they want us to do a pre-trial and all this, she had a counter claim. I'm like, I call my client, I'm like, this is different, obviously, but I'm like, you're gonna pay me more than what your client's for. Yep, time to go to this kid.
That little room right up there, the bailiff's home away from home. It's that little room out there. in the back.
Yeah,
So
it is. Yeah, they'll hang out there.
I see a cot in there.
Did you get a hold of your witness? Did you get a hold of your witness?
Left her a message.
Yeah, I might have a little bit of time to get on this. My document company didn't buy my activities, so I got 2 boxes. And I don't use them all, but I need to pull them out. Of the 175, maybe the 20 that I want to use,
Mhm.
I need to have them right here, so I'm not running over here all the time. Which I'll do tomorrow. Yeah, that was a mess. DocuPros is what they were called.
Yeah, I think that's all ours. Kinkos, or not Kinkos.
Well,
FedEx.
we went, she had one set, that's the DocuPros, they double sided, didn't do the Excel spreadsheets big. We did do FedEx on one, they wouldn't call back on the other. So we had the DocuPro do the second one, just. I don't know if you're got a case in Delaware, company called Farkas. All you have to do is let them know at 7 o'clock tonight what you need for the next day, and it shows up.
Nice.
I mean, it's there. They do witness binders for you. They do all of it. In this case, I wish I would have had a little bit more time to do the witness binders and stuff. But I was counting on DocuPros to do it. It didn't happen. So we kind of got that. We got them. It's just been a lot easier. But I got trying to move you guys a little bit. I take up the library.
This is a pretty small table.
It is. Good job. Who's keeping home? Hey, well, I'm still in trial. I got about a minute. So. Yeah. Okay. All right. Right, bring it in. Good. Okay. All right. I'm sorry. Just give it. Okay. Sorry. So I was gonna go with my children. He should have gone this morning.
Quiet. Check with them. Cheers.
Hey, I've got 2 seconds. Call Frank. He sent us his trust documents. I told you about it. He told Cindy to give it to you. He wants to reduce the price.
Give my card, send it to me.
I call Frank.
He's right.
Client right
I
now.
call her. I got
I've got a friend. So he's going to refer to the
Wow.
molestation by clergy case.
Oh, man, really? How did that, you get a good judgment on it?
Well,
Was still
I guess
ongoing?
it was heterosexual and teenager girl.
Oh,
So,
that's rare.
yeah, but anyway, so after he got his share, he refers everything. I think he's paid by some legal insurance company. So he gets all these crappy cases. And he'll call me if he thinks they're worth some money.
You know, there's a
Then
big,
he refers them all to me anyway,
Right.
just call Bacon.
there's, what's the name of it? I knew a guy that worked for a law firm based out of Norcross, and it's like Legal Shield or one of those places, they did a lot of those cases for them,
Yeah,
traffic court crap and things like
yeah,
that.
and the stinky stuff, my car was wrongfully repossessed. Well, how was it wrongfully repossessed? Well, I didn't pay. They shut me up from my garage.
Yeah.
Always kept it in there.
Good. Good. I haven't told you about the Bob Mark case.
Yeah, with me.
When he kept calling my office and going, tell your client not to, I'm like, I can't. Tell him not to. Talking to his friend, who was the, well, yeah. And then they settled it on the room, and I was pissed, huh? Yeah, this family, everything I know. Well, no, they give you the name of that. Well, we'll see. Yeah, correct. You might get it, who knows?
That's it.
You know, the judge is looking at this going like, this is going on, that's your nine. You know, he was thinking about, you know, where's your other witness? Because you're back up.
I hate when I'm a cliff.
Oh, it was on the floor or something.
No. So.
I had to freaking run back from the bathroom. I thought I was gonna be late. Oh, awesome.
I see for
Remain seated. Court come to order. Is there echo in here? Exactly what you said.
Well, he was whispering in the ear.
That's all right. Probably always better to err on this. Some judges would freak out. Mr. Dakin, ready for the jury?
Sorry.
Ready for me to bring the jurors in?
I wanted to let you know, I left our expert a message and told her she needed to be here probably in the morning.
Okay.
So I'll follow up with her tonight.
She didn't respond saying no problem.
I got her voicemail.
She's probably on the stand right now in South Carolina. Where in South Carolina? Okay. I'd never heard of upstate South Carolina, but one of our potential jurors was from upstate South Carolina.
It was Toombs County, Georgia.
Was it Toombs County?
Oh, where the expert is? Well, she can be here tomorrow morning then. I thought you guys said she was out of state.
I thought she told us South Carolina.
No, it was Toombs County, and I can't remember.
Okay, great. Thank you for leaving her the message. Mr. Ford, anything before we bring the jurors in?
Oh, no, I just had my son, just checking the phone.
Good news, bad news?
That's all right.
I'm sorry.
He just gotta get to the hospital. My wife's gonna go get him.
Okay. You need a break?
No.
Okay, all right.
What's going on?
Stay here.
Okay, yeah. It's not. Okay.
So that's me.
No,
All right, adjourned. Joseph, President, accounted for.
Thank you, Deputy Gordon. You all can be seated. See, some of you took my advice, and at least a couple of you are sitting in different places. But some people, they find a spot that fits them just right. There they are. When we paused, the plaintiff's team was about to call Mr. Rabai to testify. Is that still the plan?
Yes, sir.
All right, Mr. Rabai, if you come on up, Deputy Gordon's going to swear you in. You can take a seat, please.
President. You swear or affirm that testimony you will give the truth, the whole truth, and nothing but truth, so help God.
I do.
Do I have a seat? You state, spell your name for the record.
Noor Rabai, Nour, last name is Rabai, Rabai. Thank you.
Do you have a range of exhibits that you're giving him? It's not essential because you're going to call them out each time you admit them.
Or we should say the first act is 4 through 34.
Okay. It's at least 4 through 34. We'll go from there. And those are not admitted. Those are simply just put up on the bench, on the witness stand for availability. Thank you for handling it that way.
If you would, Mr. Rabai, look at plaintiff's exhibit 4, which is at the top of the stack. And that's the original certificate of incorporation and articles of Milanai Investments LLC. Is that correct?
Yes, sir.
That document's dated June 12th, 2017.
Yes, sir.
And the second page is the articles of organization. Is that correct?
Yes.
And you're listed as the organizer and authorizer. Is that correct?
Yes.
Let me get you to take a look at plaintiff's exhibit 5. And that's exhibit is the original operating agreement of Milanai LLC, isn't it?
Yes, sir.
Is that your handwriting that appears on that exhibit up at the top?
Where it says original operating agreement 2017?
Yes.
Yes.
That operating agreement lists you as the sole member of the LLC, correct?
Yes.
At what point in time did you begin engaging in transactions with Mr. Hamade under Milanai Investments LLC?
I believe around 2017.
And you recall what the terms of that agreement were with Mr. Hamade at that time?
It was to purchase real estate and investments.
Did you define any rights and responsibilities of the members of the LLC?
I don't recall at that time.
Do you recall who would be responsible for the management of the LLC?
Yes, Noor Rabai.
There weren't any writings, were there, reflecting the terms of your agreement with Mr. Hamade at the time you began engaging in the business of Milanai LLC?
What was the first word? There weren't any.
There weren't any written agreements, were there?
No, not around 2016. No, 2017. before this.
Within the year following the formation of Mila and Naya, capital contributions were made in cash to Mila and Naya by both you and Mr. Hamade, is that correct?
That is correct.
And those capital contributions were used to acquire properties, is that true?
Most of it, not all of it.
What did the other money go to?
There's a spreadsheet that shows transactions that went between, for finances that went between myself, Mr. Hamad, his sister, and somebody, and his mom and dad. Or his father, not his.
Okay, your wife's father.
Yes.
Got it.
Did that have anything to do with Mila and Naya?
Yes, sir.
Okay, explain that.
Mr. Hamad started the Google Sheets in 2016, I think, around 2016, 2017. And there was a transaction report for cash and or equivalent that went between myself, his sister, his brother, and people overseas.
How did that involve Mila and Naya?
The Google Sheets that he started all related into Milanaya. All that cash transactions and the money orders and all the money that funneled in through that was all put on the Excel spreadsheet.
So you're talking about an Excel spreadsheet, but I hear you talk about a Google spreadsheet. Are those the same or are those different?
Yes, Your Honor. It's the same. It began as a Google Sheets and we transferred into an Excel Sheets.
So when you're talking about the two, you're talking about the same, just evolving over time.
Yes, Your Honor.
There weren't two sets of books, the Google books and the Excel books.
Yes, Your Honor. It just evolved.
How did entry on a Google or Excel spreadsheet mean that it involved Mila and Naya?
Well, we continued to utilize that same spreadsheet for all our property transactions, which Mr. Hamade and myself went over on a yearly basis, and we approved all the transactions.
If it listed people involved other than you and Mr. Hamade, and an entity other than Mila and Naya, are you saying all those other people were somehow interested in Mila and Naya?
That's not what I'm saying.
Just the fact that something was entered on a spreadsheet that also happened to apply to Mila and Naya doesn't mean those entries apply to Mila and Naya.
It did for myself and Mr. Hamade.
Just you two.
Yes.
Let me get you to take a look at plaintiff's exhibit 6. And that is an email dated June 19th, 2019 from you to the accounting firm that you had at the time to do the tax returns in Illinois. Is that correct?
Yes. Yes, sir.
And in that document, you state, Your Honor, let me tender plaintiff's exhibits 4, 5, and 6.
Is there any objection to 4, 5, and 6 are admitted?
And that document state, quote, also as far as Ali Hamadi, he is a 50/50 owner since beginning of 2018. We combined our funds, and it says out, but that was a typo for ours, right, Brett? We combined our funds and purchased the properties needed. Everything is in my name's internal loan due to my credit rating and my ability to borrow. He will take on that risk in 2019, but as a partnership, this is how we planned it. Did I read that correctly?
Yes, sir.
Was that true statement true when it was made?
Yes.
So as of the beginning of 2018, you recognize Mr. Hamadi as being a 50% owner of Milanaya.
Yes, sir.
And by this correspondence to your accountant, you recognize that Mr. Hamadi had made capital contributions to acquire properties in connection with the business of Milanaya.
Yes, sir.
Do you recall today what those contributions were?
Overall?
Back?
Oh, no, I don't recall. Back in
prior to the time
2018.
you wrote this letter.
No, sir, not in 2018.
But Neil and I began acquiring property under its name in 2017, right?
Yes, sir.
So would it be a correct statement to say in connection with properties that were acquired by Milanaya prior to the date of this document, which was June 19th of 2019, Mr. Hamade had made the contributions required of him to purchase the property?
He did or did not?
He-
I would have to look at the Excel spreadsheet that we have.
Okay, you
Yep.
can't tell us here today.
If you pull up the exhibit, I'm pretty sure I could.
Well,
Which exhibit?
Oh,
The Excel
the Excel
spreadsheet?
spreadsheet.
Okay.
Exactly which Excel spreadsheet are we talking about?
It would have been the one that has been accounted for since 2015 transaction onward to about 2021, which we
Is
submitted.
that document in this case?
Yes, sir.
Can you pull it up here? Yeah. No, I'm at price.
Exhibit 8.
Well, before it's up on a screen, you may want to look at it. And we may need to talk about something outside the presence of the jury. If you have other things you want to cover with Mr. Rabai, you could do that while counsel is getting it up on a screen. And then I don't know if Mr. Dakin could look at it. The representation is that it was part of discovery. So hopefully one of you would recognize it. And we'll see. But for now, it's not in evidence, so I don't want it going up on a screen.
Neither do I.
Okay.
Because it's not in evidence. I don't believe we've seen it.
Okay.
So moving on, do you still have plans to do it one outside? Should be two.
1? Yes.
And that's that's the written operating agreement between you and Mr. Hamade concerning Miladaya dated January 5th of 2021. Is that correct?
Yes, sir.
If you look at the last page of the document, that's your signature on the document, correct?
Let me just get back there. Yes, sir.
If you look at paragraph 3 of the document, it's recognized that the company was formed in June of 2017. Is that what paragraph 3 of the document provides?
Yes.
So even though this is dated, this written operating agreement between you and Mr. Hamade is dated January 5th of 2021, y'all recognize y'all have been operating together as a business since the original formation of Milan, correct?
Yes, sir.
And the only members of the LLC listed in that operating agreement are you and Mr. Hamade, correct?
Yes, sir.
If you look at paragraph 6 of the document, titled Members' Capital Contributions, it states that the member shall make a capital contribution to the company as follows: cash payments of $50,000. Did I read that correctly?
Yes, sir.
Did that provision relate to the previous contribution of funds by you and Mr. Hamade that were made, as indicated in your email correspondence to the accountant, that we have combined our funds to purchase properties?
I couldn't answer that because I believe Mr. Hamid created this this specific document.
I believe we established that's your signature on. Did you agree to this document?
Oh, yes.
But are you telling us today you don't understand what the document meant when you signed it?
No, I just a cash of $50,000. That's the one part I don't, capital contribution, Mike.
So you don't know if anyone made a capital contribution of $50,000 cash. Is that what you're telling the jury?
Oh, yes, we did. Based on our Excel spreadsheet, yes, we did.
If you look at paragraph 7 of the document, it's on the second page. It's entitled Distributions. It states, the members may make such capital contributions, each a capital contribution with the capital and contribution capitalized, in such amount and at such times as the member shall determine The member shall not be obligated to make capital contributions. The member may take distributions of the capital from time to time in accordance with limitations imposed by statute. Did I read that provision correctly?
Yes, sir.
So this language left it up to each member to determine if he would make any additional capital contributions to the LLC. Is that correct?
I believe so.
Let's go to paragraph 11 of the agreement. And it provides in part that the company assets shall be deemed owned by the company as an entity, and the member shall have no ownership interest in such assets or any portion thereof. Title to any or all such company assets may be held in the company name, one or more nominees, or in a street name, as a member may determine. Is that correct?
Yes.
So your agreement with Mr. Hamade allowed the Neil and I investment properties to be titled in the names or in names other than Neil and I.
At that time, the majority of the properties were still under my personal name.
And this agreement recognized that you could do that, but they'd still be Neil and I properties.
I believe so.
You don't dispute that the 10 properties we've been talking about so far today are Neil and I properties.
Not at all.
Now, paragraph 12 of the operating agreement is entitled Dissolution and Liquidation. Let me get you to take a look at that. Okay. One of the causes for dissolution is the company shall dissolve and its affairs shall be wound up on, quote, the determination by the member that the company shall be dissolved. Is that correct?
Yes.
Who kept the books, wrote checks, and had authority to sign checks for Neil and I?
No Rabai.
I'm sorry,
No Rabai.
you.
Yes, myself.
The checkbook, I believe you opened the account for Neil and I in June of 2017 at the time of its formation, right? Is that correct?
I don't recall the exact date, but sometime around that.
The checkbook for that account was physically kept by you, correct?
We both had access to that.
But
Well,
the checkbook itself,
The paper checkbook, you both, like it was in a little glass dome in a shared house, or how, if he's in if Mr. Hamade is in California and you're in Georgia, how do you both have access to the checkbook?
Oh, the checkbook? No, I had access to that.
you actually kept it at the 222A Fairburn Road property, didn't you?
Yes, sir.
And before that, I think at your residence.
Yes, sir.
Okay, the 10 properties, let's see if I can get through a list of them. 222A Fairburn Industrial Boulevard, that was one that was a Neil and I property.
Originally, it was in New Rabai and PETA.
Neil and I acquired the deed on September 20th, 2017, do you recall?
I don't recall.
Wasn't the warranty deed given to Neil and I?
I don't recall about the warranty deed. I know the loan.
Okay. Well, between the loan and the warranty deed, you can't tell us, your jury today, whether or not it was in the name of Neil and I, that the warranty deed was titled to Neil and I.
We could pull up the exhibit that we put on the screen before for me to look.
That would be one of your exhibits?
I believe so, yes.
Well, we haven't seen any of your exhibits, so they haven't appeared on the screen as of yet.
It was whatever was put up on the screen earlier, the 10 properties.
There was a list of 10 properties put up on the screen during the defense opening.
Statement.
So whether you want to call that an exhibit, it was a demonstrative for the opening. So if it would facilitate, if you're going to want to cover all 10 properties, having a list of them on the screen may facilitate. That's not going to necessarily tell Mr. Rabai when a warranty deed was acquired or this or that. If you have documents to help him with this, that's great. I don't know that we're going to get a lot from quizzing Mr. Rabai as to the month, day, and year that certain things happened 9 years ago, but it's your examination.
Was 150 Brooks Drive one of the Milanaya properties?
Are you talking about the deed?
Right now, I'm just talking about whether they were under the umbrella of Milanaya.
Yes, sir.
180 Windfair.
Yes, sir.
125 Brooks Drive,
Yes, sir.
163 Hickory Road,
Yes, sir.
180 Ridgeway,
Yes, sir.
222B Fairburn Industrial Boulevard.
Yes, sir.
Okay, that's also referred to as in Pregulin Ray for some reason. isn't it?
On tax records, yes.
270 Lakemont Drive,
Yes, sir.
86 Overby Drive,
Yes, sir.
300 Lakemont Drive. Those are the 10.
Yes, sir.
Some were acquired in your name, some were acquired in Mr. Hamade's name, and some were acquired in Milanaya's name. Is that correct?
That is correct.
Now, over the course of the next couple of years, from 2017 until 2022, really beginning in 2021, 6 of those NELA properties were sold, correct?
Yes.
One of those was 300 Lakemont Drive,
Yes.
and that property was financed in Mr. Hamade's name.
Yes.
You discussed with Mr. Hamade the acquisition of that property as part of the Neelanaya properties, correct?
Yes, he pulled the loan and I assisted it.
Let me get you to take a look at plaintiff's exhibit 7.
Okay.
And that's the closing statement when 300 Lakemont property was sold. It's dated March 15th, 2021. Is that correct?
Yes, sir.
Your Honor, I attended plaintiff's exhibit 7.
Any objection to plaintiff 7?
No.
Admitted.
And that shows the net proceeds from the sale, does it not?
Exhibit 7 is when we purchased it, not the sale.
Sorry, Your Honor.
Take your time.
Because the borrower is Ali Hamid.
You are correct. Shows the borrower being Ali Hamade. And that's the settlement statement when it was acquired.
When it was acquired, yes, sir.
Let's go to plaintiff's, let's go to 163 Hickory Road. You discussed with Mr. Hamade the acquisition of that property as part of the operations of Milanaya, correct?
That is not acquisition. That was this is when we sold it. Exhibit 8 is a sell, not an acquisition.
Well, I'm not asking you about Exhibit 8 yet.
Oh. It was,
163 Hickory Road was part of the properties acquired for Milanaya. And you discussed that with Mr. Hamade before acquiring the property.
oh, yes, yes.
Now let me get you to take a look at Plaintiff's Exhibit 8 and ask you if you can identify that for us.
Yes, that's the altar for the sale of the property at 163 Hickory Road.
That's the closing statement.
Yes, sir.
Your Honor, I attended Plaintiff's Exhibit 8.
No objection.
Admitted.
The net proceeds of sale were split 50-50 between you and Mr. Hamade, correct?
Yes, sir.
180 Ridgeway, that's another piece of property that's part of Milanaya. And you discussed with Mr. Hamade the acquisition of that property, correct?
Yes.
Let me get you to take a look at plaintiff's exhibit 9. And that's the deed and closing statement on 180 Ridgeway at the time it was sold by Nehemiah, correct?
Yes, sir.
Stated October 11th, 2021.
October 1.
11th, 2021.
Yes.
Your Honor, we tender plaintiff's exhibit 9.
No objection.
Admitted.
The net proceeds of that sale were split 50-50 between you and Mr. Hamade, correct?
Yes, sir.
When you did the distributions, you were the one that calculated the distributions, weren't you?
For the sale of the properties?
Yes.
Yeah, we just used the Alta and we split it 50-50.
Let's go to 270 Lakemont Drive. That was a property financed by Mr. Hamade, correct?
Yes, financed by Mr. Hamad, correct.
And you discussed that acquisition of property with Mr. Hamade, correct?
Yes.
Let me get you to take a look at plaintiff's exhibit 10. And if you could identify that for us, please.
Again, Alta, which is a closing settlement statement of the sale of the property.
And that's 270 Lakemont Drive dated October 13th, 2021, correct?
Yes.
Your Honor, we tender plaintiff's exhibit 10.
No objection.
So it's admitted.
The net proceeds of that sale were split 50-50 between you and Mr. Hamade, correct?
Yes, sir.
86 Thomas Overby Drive, this is in Sharpsburg, Quita County, which is a little bit different than most of these other properties were in Fayette County, correct?
Yes, their counties, they're next to each other.
86 Thomas Overby Drive, that's in Quita County. This property was acquired in connection with the operations of Melanite, correct?
Yes, sir.
And you discussed that acquisition with Mr. Hamade.
Yes, sir.
Because you should take a look at plaintiff's exhibit 11 and ask if you could identify that for us, please.
This is the closing statement for 86 Thomas Overby.
And it's dated January 13th, 2022.
Exhibit 11?
Yes.
I got October 12th, 2021. Or the disbursement date of October 25, 2021.
Is that the closing statement?
This is Exhibit 11, which is the closing statement. Yes, sir. This is what I have in front of me.
So it says 2021.
It says October 12th, 2021, and the settlement date, disbursement date is October 25th, 2021.
The net proceeds of the sale of that property were split 50-50 between you and Mr. Hamade.
Yes, sir.
Let's go to 222B Fairburn Industrial Boulevard. You discussed the acquisition of that property with Mr. Hamade, correct?
Yes, sir.
Take a look at plaintiff's exhibit 12 and ask if you can identify that for us, please.
This is a closing statement for 222B, Fairburn Industrial Boulevard.
And is the closing statement dated January 21st, 2022?
Yes, sir.
The net proceeds of that sale were split 50-50 between you and Mr. Hamade, correct?
Yes, sir.
Were 222A and B physically connected or just near each other?
Just near each other, but two separate buildings.
Okay.
Yes, sir.
Same kind of buildings?
Yeah, one was just same facade. One was just 7,500 square feet. One was just 10,000 square feet.
Okay.
Yep.
Your Honor, I tender plaintiff's exhibit 11 and 12. 11 if I didn't do it before.
You did not. Any objection to plaintiffs 11 and 12?
No objection.
All in.
So as of January 21st, 2022, 6 of the 10 properties that have been acquired in connection with the operations of Melanaya have been sold. Is that correct?
Yes, sir.
So there were 4 remaining properties. Let me get you to take a look at plaintiff's exhibit 13. And if you could identify that for us, please.
Secretary, a certificate of organization for Rabbi Investments LLC.
And the date of incorporation shown is August 16th, 2019.
Yes, sir.
Your Honor, we tender plaintiff's exhibit 13.
No objection.
Admitted.
So Rabai Investments LLC was formed approximately 2 years after Milanai Investments LLC, correct?
Correct.
You're shown as the organizer of Rabai Investments LLC.
Yes, sir.
What capital contribution to Rabai Investments LLC, if any, did you make at the time you formed Rabai Investments LLC?
I don't recall.
Do you recall whether or not you made a capital contribution?
I'm sure I did, yes.
But you don't recall the amount or recall doing?
No, sir. I don't recall the amount.
Who were the original members of Rabai Investments LLC?
Noor Rabai?
Have there ever been any other members of Rabai Investments LLC?
No, sir.
Mr. Hamade was never a member, correct?
Correct.
Mr. Hamade never had any say in connection with the operations of Rabai Investments LLC.
Correct.
What duties did you perform on behalf of Rabai Investments LLC?
Investments, purchases.
Do you still perform those duties on behalf of the LLC?
I do.
And what was the purpose of forming Rabai Investments LLC?
Just different investments.
All connected with real estate or
Not, mostly, but not everything.
what else did it include?
Just different types of assets.
What's an example?
Um,
Not real estate.
a vehicle, vehicles.
Let me get you to take a look at plaintiff's exhibit 14. And that is a copy of Rabai Investments LLC operating agreement. Is that correct?
Yes, sir.
That's the original operating agreement. Have you ever changed that since the date you incorporated Rabai Investments LLC?
I don't recall.
Is it a fair characterization of the provisions of that operating agreement that you had and have full control of all decisions and actions taken by Rabai Investments LLC?
Yes.
Now, after Rabai Investments LLC was formed, it said about acquiring properties on its own, right?
Yes, sir.
Let's go through a list and see if you can identify these as properties acquired by Rabai Investments. 140 Medford Drive, Fayetteville, Georgia.
Yes.
180 Medford Drive, Fayetteville, Georgia.
Yes, sir.
105 Walker Avenue, Fayetteville, Georgia.
Yes.
308 Morgan's Turn, Peachtree City.
Yes.
96 Winthrop Drive, Sharpsburg, Georgia.
Yes.
119 Creekside Way, Noonan, Georgia.
Yes.
26 Jade Point, Sharpsburg, Georgia.
Yes.
38 South Avenue, Fairburn, Georgia.
Yes.
And 67 Thomas Overby.
Yes.
Rabai Investments LLC was acquiring and selling properties at the same time that Milanaya Investments was acquiring and selling properties, correct?
Correct.
Were the properties acquired by Rabai Investments LLC primarily for rental purposes or for resale purposes?
Primarily for rental purposes.
Was Rabai Investments LLC investing funds to improve those properties that were acquired by Rabai Investments?
If they needed it, yes.
Rabai Investments was actively renting those properties?
Actively running?
Actively renting those properties?
Oh, yes, sir.
Now, would you agree that as those properties were owned by Rabai Investments LLC, no funds from Milanaya Investments should have been involved in connection with expenses incurred on those properties?
Yes, that's correct.
Now, previously, we established that you physically kept the checkbook of Milanaya, correct?
Correct.
And Mr. Hamade did not have physical access to the checkbook, nor did he write any checks on the checkbook.
Correct.
Let's talk about some of the checks that were written. Take a look at plaintiff's exhibit 15. And that is check number 2514 to auto owners dated July 15, 2019 for $88.85. Is that correct?
That is correct.
Is that your handwriting on the check?
Yes.
Is that your signature on the check?
Yes.
Your Honor, we tender plaintiff's exhibit 15.
No objection.
Do you want to get all the checks in at once so we don't have to go through that process for each one? Or are you going to not? I'm just noticing the upcoming exhibits are other checks. So Mr. Rabai could look at all of them. My signature, my handwriting, I wrote those checks.
Okay.
And then they're all in, assuming there's not an issue from the defense. But that way we just have one admission colloquy.
That works for me.
Okay. So Mr. Rabai, if you go through exhibit 24, so 15 through 24, all purport to be checks. If you could look at those to see if those are checks from Milanai that you signed and filled out. Yes.
Exhibit 15 and 16. I did write those out and signed them. Exhibit 23, 22, 21, 20, and 19 and 18 were all signed by myself, but they were written out, I believe, by my secretary.
Okay. Not by Mr. Hamade.
No,
Okay. So either you or your secretary put the payee, whoever's getting the money in there, Bank America, AutoZone, you signed every one of them.
I did sign every one of them, and the reason I tell the difference because her handwriting is different than mine.
Sure. So you or what I'm gonna call your agent, filled out the check.
Yes, sir.
All right.
Now we tender plaintiff's exhibit 15 through plaintiff's exhibit 24.
True four?
Correct.
Okay. Any objection?
No, no objection.
They are all admitted.
So let's go back to plaintiff's exhibit 15.
Okay.
That check is labeled for being for 145 North. Is that correct?
145 Northwood, yes.
Milanaya didn't own any property at the address of 145 North, did it?
Correct.
Did Rabai Investments own property at that address?
Yes.
So this was a check. Was it written to pay auto owners as an insurance company? Was it written to pay house insurance?
Yes, sir.
So it was a check written from Milanaya accounts to pay for house insurance for property owned by Rabai Investments.
Correct.
Exhibit 16. There are two checks, number 2529 and 2544. Those again are Milanaya checks, correct?
Correct.
Both of them are to auto owners insurance.
Correct.
Check number 2529 simply is labeled as being for home insurance premium, correct?
Correct.
There's no way to tell from that check whether the insurance premium was being paid for property owned by Milanaya or property owned by Rabai Investments, Inc. Is there?
No, that's incorrect. We can just go back and look at the P&L.
I'm talking about looking at that check.
Looking at this check, it just says homeowners premium, insurance premium.
Check number 2544, which is also part of that exhibit. Its 4 is labeled 2399. That check was written to cover property located in Sharpsburg, Georgia, correct?
Correct.
And that was property owned by Rabai Investments LLC, correct?
Correct.
Go to plaintiff's exhibit 17. That was a check for $2,628.50 and an invoice attached from Showtech Stone Inc. dated September 17, 2020, correct?
Correct.
And that check is labeled for 119 Creekside. Is that correct?
Correct.
Milanaya never owned any property at 119 Creekside, did it?
That is correct. It did not.
Rabbi Investments did, though, correct?
Yes.
Mr. Rabbi had no interest in that property whatsoever, did he?
Mr. Rabbi, I'm Mr.
I'm sorry, Mr. Hamade.
Correct.
Go to the next check, plaintiff's exhibit 18. This is a check dated April 2nd, 2021 to Beyond LED Technology for $1,074.75. That check has an invoice number on it. Is that correct?
That is correct.
And you recall during your deposition, you were able to track down that invoice?
Yes.
And that check was written to pay for items delivered to one of your Peter Restaurant franchisees in Columbus, Georgia. Is that correct?
That is correct.
Milanaya had nothing to do with a Peter franchisee of yours in Columbus, Georgia, did it?
This is actually for the 222A warehouse.
Why was the product delivered to Columbus, Georgia, if it was for a warehouse in Atlanta, Georgia?
Nadeem Chaudhry was actually the authorized buyer of those LEDs. That's why it was invoiced to him or shipped to him.
If it was invoiced to him and shipped to him, why did Milanaya pay for it?
Because he brought it up to us.
You had property shipped to Columbus, Georgia to bring to Atlanta. Is that what you're telling us, jury?
Yes, sir.
And what supposedly was that property used for?
It's 2x4 LED panels that we only use at the warehouse.
Did the gentleman who ordered those items have a franchise of the Peter Restaurants in Columbus, Georgia?
Yes, sir.
And again, Milanaya has nothing to do with a PETA franchisee located in Columbus, Georgia.
Milanaya has what? I'm so sorry.
Nothing to do with a PETA franchisee located in Columbus, Georgia.
Correct.
Except that you ship product, you paid for product to be shipped to him, for him to bring it back to Atlanta, supposedly.
Well, he's a LED authorized dealer, so he bought the product for a really good price. That's why we bought it through him.
Why wasn't it shipped to Milanaya?
He delivered it to us.
Let's go to exhibit number 19, check number 2655. This is written to Rabai Investments, dated May 14, 2021, for $325. Now that check is labeled as being for Romero May, is that
Yeah.
correct?
Correct.
As I understand it, Mr. May did maintenance work on properties not only for Milanaya, but also for properties owned by Rabai Investments LLC, correct?
Correct.
Okay, from this check, you can't tell what properties Mr. May worked on for which you wrote a check to Rabai Investments to cover the costs, correct?
I believe the secretary wrote this one and she would have known. Yes, she would have written it out
I'm
for,
here today, Mr. Rabai.
I was just explaining, sorry.
Let me get you to take a look at plaintiff's exhibit 20, check number 2817, written to you personally, June 26, 2021, for $683.56.
Correct.
Four line doesn't indicate anything about what it's being paid for.
Correct.
So we have no idea what this check was written to you for from Neil and I, correct?
Yes, this is another one the secretary wrote out.
And you signed.
Absolutely.
Let's go to exhibit 21, check number 2696, written to Rabai Investments, November 8th, 2021. That's another check you wrote to Rabai Investments to cover maintenance work by Mr. Romero May, correct?
Correct.
And there's nothing from that check that indicates whether it was for work on properties owned by Milanaya or for work on properties owned by Rabai Investments, correct?
It was maintenance work for Milanaya.
And by looking at that check, how can you tell that?
Again, the secretary wrote it out, so she would have had some kind of documentation to support that.
Your Honor, I've got to object to these hearsay explanations that someone else wrote the check and she would know.
I don't know that it's hearsay. It's just saying he doesn't know and he's identifying someone who might, who I guess could be called as a witness, but
You don't plan on calling her as a witness, do you?
I don't believe so.
Let's take a look at plaintiff's exhibit 22, check number 2698, made out to CMA Atlanta, November 8th, 2021, $175.
Yes, sir.
What is CMA Atlanta?
Again, this one the secretary wrote out, and I don't know, but I believe we can look it up.
The check is labeled as being from 119 Creekside, correct?
Correct.
And we previously established that Mila and I had never owned property at 119 Creekside, correct?
Correct.
I'm getting the impression that if your secretary put a check in front of you, you just signed it regardless of what it was for. And it came out of the Mila and I account.
Well, everything.
Am I misunderstanding what I'm hearing here?
Well, you're seeing a check, and we have, obviously, we do P&L, so we would have seen it in the P&Ls. But we did have a lot of properties and a lot of restaurants. So there might have been at a time where we were signing 100 checks a day, and it might have just.
Messed up.
Yep, absolutely.
I agree. Exhibit number 23, check number 2905, made out to you, dated December 21st, 2021, for $720. What's that check for?
I don't recall, but this is another one the secretary wrote out.
Doesn't the four line indicate it's for 909 Sandy Creek?
Yes, but I don't know what it's for, what was the $720 was for.
but it would be associated with that piece of, you wouldn't put that piece of that property name, if it were for a different piece of property.
Correct.
Okay.
Yep.
Neil and I had never had any property located at 909 Sandy Creek, correct?
No, sir.
That property was owned by Rabai Investments LLC, correct?
I don't know if it was Rabbi Investments or Rain R Enterprises. I'll have to get back to you on that one.
Rain R Enterprises, that was another one of your LLCs.
Yes.
Mr. Hamade didn't have anything to do with it.
No, sir.
Mr. Hamade didn't have any say-so in it.
Correct.
Go to Exhibit 24, and this is a series of checks, 1, 2, 3, 4, 5 checks. They're all written to either you individually or PETA. Let's look at numbers 25, 23, September 3rd, 2018, $8,970.
Yes, sir.
2524, September 3rd, 2019, written to you, $11,800.
Yes, sir.
Number 2525, September 3rd, 2019, written to you for $5,948.02.
Yes, sir.
Number 2526, September 3rd, 2019, written to you for $47,155.85.
Yes, sir.
Number 2557, dated November 25th, 2019, $80,000, written to PETA.
Yes, sir.
Will you accept my calculation that the total amount of these checks is $153,874.39?
I'll have to take your word for it.
Okay. I appreciate you doing that.
Yeah.
All of these checks were written within 2 months after the formation of Rabai Investments LLC. Is that true?
Correct.
Were you paying yourself back for capital contributions made to Milanaya Investments LLC?
No, sir.
What were these checks paid for?
It says Milanaya Payback, C Records, Advance. The other one says Milanaya investment advance C records.
Advance for what?
I don't recall, but it says Milanaya Payback Advance C records. Milanaya Advance C records, and the last one was an advance to cover $80,000 that Peter Franchising gave to Milanaya, and it was paid back. And we have record proof of that too.
But from looking at his checks, we don't know what was being paid back, what the original money was given the Milan for. For these capital contributions you were making on your behalf to acquire properties from Illinois.
So if you look back at the Excel spreadsheet, it will give you an understanding of where the money went and where it flowed, and the date stamp and the property and to who, whether it be Ali Hamade or Nur Rabai.
And I think were you able to find an exhibit?
Could be somebody exhibit A, you.
Yeah, I was curious, is Defense Exhibit 8 the spreadsheet?
That's the one he told me about. He's got several spreadsheets, but that's one of them.
Okay.
Is that the one that starts with December 1st, 2015?
Yes, sir.
I can bring it up on.
No, it's not in evidence yet. Mostly we're trying to cross the bridge of, did plaintiff have this? And you don't need to decide right now. That's one of we can sort it out after we break for today. Council can show you, here's where we provided it or didn't, and we'll sort that out. But you've got a witness anxious for his next question.
Let me get you to take a look at plaintiff's exhibit 25.
Yes, sir.
Now, these are 5 pages of excerpts from, I call them text messages, and you said, well, no, the WhatsApp messages. But there's really no difference between the text messages and WhatsApp, because you type into your phone.
Let's not go there. You're aging yourself and dating yourself. If they're WhatsApps, let's call them WhatsApps.
Your Honor, I'm a dinosaur to where I do not know my cell phone number. It's seldom. But in any event, these are messages between you and Mr. Hamade.
Yes, they're WhatsApps. Yes.
And, Your Honor, we tender plaintiff's exhibit 25.
Any objection to the admission of plaintiff's 25?
No objection.
Admitted.
Okay, there are 5 pages of excerpts from text messages between you and Mr. Hamade. And these
Yes.
were actually produced on your behalf in this case. Let's go to the first page of the document of the exhibit. And look at the text message showing a date of July 28th, 2021 at 6:55.22 p.m.
You said July 28th? Oh, up top. Yes, sir.
And that's from you to Mr. Hamade, correct?
Yes.
This message states, Alex, we need to finalize your audit with your accountant in Lebanon by the end of next week. So after it's all finalized, I can work on liquidating all assets. You can buy it out or we can sell them off. With all 9 properties, we should be able to close the books by the end of the year. My goal, tell him to do all the work on his end that he needs to do so I can just review it and respond to any questions, concerns he may have. It's better this way so it doesn't affect our relationship. Did I read that correctly?
Yes, sir.
You recognize that as a message you sent to Mr. Hamade.
I do.
You were in here for Mr. Hamade's testimony about disagreement arose about Excel spreadsheet entries that you had presented. He presented them to someone else. Is this message in connection with that?
Yes.
And your response was, let's liquidate.
After we finish the audit, correct?
In the business you were talking about liquidating in that message, they were the assets of Milanaya.
Correct.
Prior to the date of that text message, had you had previous discussions with Mr. Hamade concerning liquidating the assets of Milanaya Investments?
I believe on phone calls, yes.
Do you recall when that phone call was?
It would have been right before the date stamp of this one.
Okay.
I don't recall the exact date, but it would have been right before the date of 7/28/2021.
Well, would you agree that it came up in July of 2021?
I can't agree on the date, but I know it was before that.
2021 or a previous year?
I believe in 2021, yes.
Let me call your entry on that same page of the exhibit, showing a date of August 3rd, 2021, 4:14, 41 PM.
Yes, sir.
This message states, can you let me know what you want to do with the homes? If you want to keep them for yourself, or are we selling them? Did I read that correctly?
Correct.
And that was a message you sent to Mr. Hamade, correct?
Yes.
Now excuse me, Your Honor.
You're sort of stuck. You need water and you can't get to the water. What a dilemma. Thank you, Mr. Hamadi.
You can show all the billboards,
Yeah.
water, but he can't get to it.
Behind.
Thank you. I apologize, y'all.
No, it's fine.
Now, the next four messages in the sequence on that page discuss setting up a telephone call between you and Mr. Hamadi to discuss the proposal. Is that correct?
Yes.
You don't recall if that telephone call ever occurred, do you?
I don't recall, but I know there's communication after it says free for a call.
Excuse me.
Let's turn to the next page of Exhibit 24 and look at the entry bearing the date of November 15th, 2021, 11:25 a.m.
Number 15, 2020. Okay,
And this message appears to be from Mr. Hamadi to you, correct?
correct.
That message reads, "Good morning, Noor. How is the progress on closing the property?" Is that correct?
Correct.
And the following message appears to be your response, showing a date of November 15th, 2021, in which you reply, "Two of them we are fixing up to resell, almost done. Two I may keep for myself." Now, read that correctly?
Correct.
Then there's something that says TBD ounce, and I take that to mean to be determined once. Would that be the way to read that?
Yes, sir.
That results of typing with thumbs?
Yeah,
To be determined once I get some guidance on loans, 125 Brooms and 150 Brooks. Does that refer to 125 and 150 Brooks Drive properties?
Yes, sir.
Okay. And those were Mila and I properties.
Yes, sir.
The remainder of that same message reads, "Other two sold, 163 Hickory and 180 Ridgeway. The warehouse is being viewed, but only a 1,175 bite so far." I read that correctly?
Yes.
So was that the 222A or 222B warehouse property?
That was the 222B that we eventually sold for a little bit more than that. If I do recall, we have to look at the date stamp, but I believe that's 222B.
And the 1,175 was $1,175,000.
Correct. Which we ended up selling for 1.2 million.
And dividing the net proceeds 50/50.
Yes, sir.
Now, all of the properties referred to in that message were Mila and Iowa.
Correct.
So at the time of this text, And again, that's November 15th, of 2021. The Milanaya properties were being liquidated. But you had an interest in keeping two of the Milanaya properties, correct?
Correct.
Is that correct?
Correct.
Let's turn to the next page of Exhibit 24. And I'll ask that you, not out loud, but just read through silently from the top of the page down to the message dated November 16th, 2021 at 7:51 PM.
Okay.
Okay. And see if you agree with my characterization of those messages. They dealt with the sale of properties located at 163 Hickory Road and 180 Ridgeway.
Yes.
They dealt with deposit of the closing proceeds from the sale into your personal bank account, correct?
Correct.
Mr. Hamade questioned why the closing proceeds were not deposited into the Milanaya bank account, correct?
Correct.
You responding that he was getting his fair share of the proceeds. And fair share is your word, correct?
Fair share is 50-50 as stated above. You missed it.
But that's your language. Fair share.
Referring to the 50-50 I mentioned above, which you decided to skip over.
Now, as of November 21st, you were working to liquidate all of the properties owned by Milanaya by the end of that year, correct?
Yes, working on it.
Let's turn to the next page of the exhibit. And the entry dated January 21st, 2022, 6/24/41. And that is a message from you to Mr. Hamade that says closed on the warehouse today, correct?
Correct.
And that was the 222B Fairburn Road property.
Yes, sir.
And on March 17th, 2022, on that same page, I believe, at 2:44:22 PM, Mr. Hamade texted you a message asking about the funds derived from the sale of the warehouse property. And he says, "Hi, Nor, what's the hold that the funds are not available?" Is that correct?
Correct.
And you responded that you were waiting for the other warehouse property to sell. Is that correct?
Correct.
And that would have been the 222A Fairburn Road property. And that was the one that you occupied along with your PETA companies, Rabai Investments LLC. Is that correct?
Yes.
And that same message you wrote, that leaves us with 4 properties to get rid of. 2 I have finalized, the other 2 under contract. Hopefully mid-April, we will be done with everything. Did I read that correctly?
Yes, sir.
So at this point in time, instead of selling the remaining properties by the end of 2021, you were looking to liquidate the remaining properties by April of 2022.
Yes.
And we get to the end of April, and April 28th, 2022, 2:36:58 PM, if you look at that message, Mr. Hamade sent you and asked where he and you stood in connection with the disposition of the remaining Milanaya properties, correct?
Correct.
On April 29th, you replied, we still have 4 homes to finalize, which included 86 Thomas Overby, 125 Brooks Drive, 150 Brooks Drive, and 180 Winfair, correct?
186 actually sold at that time.
You noted that it was sold in your message, 86 Thomas.
Yes,
Your April 29th message concluded that we need to figure the 3 properties above and the warehouse to finalize everything. Is that correct?
correct.
Continuing down the page, let's look at the entry on August 6, 2022 at 4:26:52 PM. Mr. Hamade again asked you for an update on the properties, correct?
6:52 PM, you said?
4:26:52.
Oh, got it. Yep. Okay.
And the next day, on August 7th, you wrote, we will need to make a deal between each other to either I buy them out or you buy them out and to get things closed out, correct?
Yes.
Mr. Hamade just replied with the letter K, correct?
Yes.
And to you, that meant, okay, I agree.
Yes.
He goes, Kay, okay, let's finish with the warehouse and let me know what do you want to do with the 3 properties, correct?
Correct.
Your reply was, I'll send a proposal for all properties sometime this week. Turning to the next page, text message from Mr. Hamade to you dated August 7th, 2022 at 7:22:38 PM. Mr. Hamade replied, okay. And there were a couple other messages in August where Mr. Hamade inquired about getting his K1 forms for the 20. I guess in August, either, do you know if they were for the 2021 or 2022 tax return?
Well, they can't be for 22 because it's the year 2022, so it's for 2021.
And after those August messages, the next text messages between you and Mr. Hamade did not occur until April 24th of 2023, correct?
Correct.
This was some 8 months after the August text messages, right?
Yes.
And that April 24th, 2023 text message to you from Mr. Hamade states, Nor, I'm lost for words. I always thought you were a fair and logical person, and I blindly trusted you on all fronts. The last thing I expected is mishandling of my trust. I ask that you do what's rightfully needs to happen to finish the partnership peacefully. Get the books cleaned and settle the balance and put it behind so we both can move forward. The holdup is not going to do us any good. Did I read that correctly?
Yes.
And Mr. Hamade wrote that to you in connection with finalizing his relationship with you and Milanai Investments LLC, correct?
Correct.
And the next thing we see, your reply to Mr. Hamade on that same day was to block him from contacting you on that app.
On an app, yes.
I want to make sure I'm clear on that, what you just said. What you're relaying to us, Mr. Rabai, is that Mr. Hamade blocked you from accessing him on WhatsApp.
No, vice versa.
You blocked him. He said what he said, and you blocked him, meaning if he tries to send you something on WhatsApp, just gets a bounce back and you don't even know it happened, or he gets an electrical shock, or what happens?
I'd like to tell the court who actually blocked it. It was actually his sister, which was my wife.
Okay, but regardless of who physically, your account
Yes.
blocked his account.
Yes.
And so, do you have any kids, Mr. Hamade?
Yes,
So if his kids were trying to reach out to their uncle, it would bounce back. using the
On
WhatsApp?
WhatsApp,
account?
yes.
On WhatsApp?
Yep.
Okay. All right.
Your Honor, we're about to get into an entirely new sort of topic.
Okay. How long do you think that entirely new topic would go?
Four and a half pages,
Okay. How many pages was the first topic we went over?
12 and a half pages.
Why don't we start this topic and we'll stop. I just want to make good use of the jurors' time. The more we cover today, the less there is to cover tomorrow. So if you all need to stand for a minute, feel free to stand. That's good. And we'll keep trucking.
Good to go?
Everyone's waiting for you.
Okay. Well, council just handed me something, which, let's go back briefly, very briefly, to claims exhibit 18, and this was the check written to Beyond LED Technology we were talking about previously. And had the invoice directed to someone in Columbus, Georgia, and shipped to Columbus, Georgia. And you indicated he shipped it back to Atlanta. Okay,
To the warehouse.
to the warehouse. You have an exhibit there?
Yes, I'm looking at it.
Beyond LED Technology was actually located in Stone Mountain, Georgia. Correct.
I don't know where they were located, but it looks like it if it's on the statement.
Something for a warehouse located in Atlanta was shipped from in the metropolitan Atlanta area, was shipped by a company located in the metropolitan Atlanta area to Columbus, Georgia, so that they could ship it back to the metropolitan Atlanta area. Is that your testimony?
Yes, sir.
Okay. Let me get you to take a look at Plaintiff's Exhibit 26. And that is a limited warranty deed and real estate transfer tax form for 222A Fairburn Industrial Boulevard, correct?
Correct.
The date of the transfer shown is March 28th, 2022. Is that correct?
Just looking for the date stamp. Is it on the first page?
I believe it may be in the first line.
Oh, yes, yes. March 28th, 2022.
Your Honor, we tender Plaintiff's Exhibit 26.
No objection.
It's admitted.
Now, this property was transferred from Illinois Investments LLC to Rabai Investments LLC, correct?
Correct.
So we kind of had a back and forth earlier about whether this was in Peter's name. That deed came from Illinois, correct?
Yes.
If you look, the signature on behalf of Illinois Investments, that's your signature as the seller of that property.
Yes.
Now, the signature line identifies you as the sole member of Illinois Investments, correct?
Yes.
That was not true, was it?
You'd have to ask the closing attorney or whoever did this.
Well, but is the statement true?
Um,
You made it or someone else did. Is it accurate to say you were the sole member of Milanai?
no, not at that time.
Is that document notarized?
Yes.
So you were put under oath when you signed your name saying you were the sole member?
It was part of the closing documents, yes.
And there's a PT 61 tax declaration form attached to that exhibit, correct?
Yes,
And it shows that no consideration was paid for the transfer of the property, the 222A warehouse property from Milanaya to Rabai Investments LLC, correct?
correct.
Did you discuss the transfer of that property to Rabbi Investments LLC with Mr. Hamade?
No, sir.
Now, if we go back to the previous exhibit, plaintiff's exhibit 25, the WhatsApp messages, and we look at those dated April 28th and April 29th of 2022, when he inquired about the disposition of the remaining Milanaya properties, you failed to mention that you had transferred the Fairburn Road warehouse property from Milanaya to Rabbi Investments the previous month. Is that correct?
That's correct.
Let me get you to take a look at plaintiff's exhibit 27. And that's a limited warranty deed on 150 Brooks Drive, correct?
Correct.
It's dated September 12th of 2023, correct?
Correct.
No, and that's from, again, from Milanaya. It was property under the Milanaya umbrella, correct?
Yes, but on the paper, it says New Rabai.
Okay. You transferred that property to Rabbi Investments Inc., LLC, correct?
That is correct, yes.
Okay. But that property was part of the Milanaya properties.
Umbrella, yes.
Your Honor, we tender plaintiff's exhibit 27.
No objection.
No objection. It's admitted.
PT, that's your signature as a seller of the property, right?
Yes,
The PT 61 tax declaration form, again, shows no consideration was paid to Milanaya for that transfer.
correct.
There was no consideration paid to anyone for that transfer.
Yeah, we just, refinanced the loan to a better term. So there's no funds taken out.
Well, this is a limited warranty deed where you transferred it from yourself to Rabbi Investments, correct? This didn't have anything to do with refinancing.
The only time I see a limited warranty deed is when I do closing, so I'm not familiar with it. And this was done by Wiseman PC.
Would you turn to the last page? Or the next to the last page? That's your signature as the seller of the property, is that correct?
Second to last page? I don't have a signature on that.
Second page.
Oh, okay, so, yes. New Rabai, New Rabai.
You didn't discuss the transfer of this property from the Milanaya umbrella to Rabbi Investments LLC with Mr. Hamade, correct?
Correct.
Let's go to plaintiff's exhibit 27.
we were
And
there.
that actually, that same exhibit transferred the 125 Brooks Drive property from the Milanaya umbrella to Rabbi Investments LLC, correct?
On exhibit 27?
Yes.
Oh, yes, a second, paragraph, correct. Exhibit
That
A.
was a deed for both Brooks Drive properties where you transferred it to your Rabbi Investments LLC, correct?
Correct.
And I don't mean to be repetitious, but Mr. Hamade had no interest in Rabbi Investments LLC, was not a member, had no say-so, had no control. That was all you.
Yes, sir.
Let's go to plaintiff's exhibit 28. And This appears to be a Southern First Term sheet dated January 26th of 2022 on properties, including the Brooks Drive property, 125 and 150 Brooks Drive, together with a settlement statement, correct?
Yes, sir.
Now, was this done in connection with refinancing those properties?
Yes, two of the properties, 125 and 150 Brooks Drive.
And the settlement statement is dated March 28th of 2022, correct?
Correct.
Your Honor, we tender plaintiff's exhibit 28.
No objection.
It's admitted.
If we turn to the last page of the exhibit, that's your signatures acknowledging receipt of the settlement statement, correct?
Yes.
And looking at exhibit A to that, plaintiff's exhibit 28, the refinancing included additional properties and not just 125 and 150 Brooks Drive, correct?
Correct.
None of those additional properties were owned by Meal and I Investments LLC, or like,
Correct.
who or what entity owned those other properties?
I'm sorry, repeat the question?
Who or what other entity owned those properties?
Rabai Investments. I'm sorry, they were owned by Newer and they were transferred to Rabai Investments at that time.
Okay, and those included 308 Morgan's Turn, Peachtree City, 96 Winthrop Drive, Sharpsburg, Georgia, 119 Creekside Way, Noonan, 25 Jade Point, Noonan, 38 South Avenue, Fairburn. Is that correct?
Yes, sir.
So you combine properties that either you or Rabbi Investment LLC own with Milanaya properties to refinance them, correct?
Yes, under a blanket loan.
And the blanket loan was in the amount of $1,100,000.
Correct.
Were the properties located at 125 and 150 Brooks Drive given as security for the full amount of the loan?
When you say security, what do you mean?
That you executed a security deed on them to the lender saying, if I don't pay the mortgage, you're secured by these properties.
No, because they were broken out. If you look at the settlement statement, they were broken out property per property. So if we were to sell them off, we would just be paying off that property.
Let's take a look at plaintiff's exhibit 29. And that is a security deed that was executed in connection with that loan, correct? Dated March 25th, 2022.
For 222 Fairburn Industrial Boulevard property?
No, plaintiff's exhibit 29.
Yeah, I'm just reading the top part. The security deed, March 25th, 2022, is made between Rabai Investments
That
and.
exhibit 29.
Yes, sir.
Yeah, okay.
I'm reading up here.
No, I'm not doubting you. I don't know how you can read that. It's like
I don't know,
1 point
it's really
font,
small.
but there may be an exhibit labeling issue that we could clear up after the jurors go home for the day, since we're at about 5 o'clock and you guys seem to be looking at different exhibits.
Number 29?
I can't read what he's got. You don't have a copy for me. The jury doesn't have a copy. So what, we're going to sort this out after the jury goes, because you guys are apparently looking at different things that both say 29. Ladies and gentlemen, we've reached a kind of natural break point for the day. When you return tomorrow morning, we'll get Mr. Rabai back on the stand. The cross-examination from plaintiff will continue. You should have in your email inbox an email from my staff that provides the basics on where to park. How many of you parked in the lot where you took a little shuttle to get here? That's where you go back tomorrow. I mean, you can always choose to park in underground. That's not free. The lot is free. And if you've got your juror sticker or your summons, you just hop on that shuttle. It will get you here. The shuttle runs every 15 minutes or so during rush hour. So being here by 9 makes it rush hour. So don't get to the lot at 8:55 saying I made it on time, because then you're gonna wait till 9. We cannot start until all 13 of you are here. So however you made it here on time, you'll think about when did you make it to the jury space down on 7. Repeat that process so that we can get rolling right at 9. The lawyers will be here, their clients will be here, but we need all 13 of you present and accounted for before we can get the witness back on the stand and pick up where we left off. Tonight, relax, unwind, don't think about 125 Brooks Drive or anything like that, or security deeds. Watch how many of you are Knicks fans or pulling for the Knicks. I'm not raising my hand. I was just asking how many of you are pulling for it. Apparently we have an anti-Knicks fan who's pulling for the Spurs. All right, so watch the Spurs hopefully finally win a game in the finals. Uphill climb at Madison Square Garden, but do something else. Don't talk about the case, no outside research. Be here by 9 o'clock. That fridge that has water in it can also hold your lunch if you don't want to go get a lunch around here. You cannot bring glass or really pokey items through security. A pen will go through, but like you bring a metal fork, they're not going to let it through security. So bring Tupperware and like kids' cutlery, plastic, something, and that'll get through. But there are also wonderful restaurants within walking distance for lunch break that will be at a more normal time and a more standard duration tomorrow. Any logistical questions from any of you? No? Leave your notepads in the jury room. Don't take them home. Just put them on the table there. That's your space. No one's going to go in there. And we'll take it from there. All right? Thank you.
All right, jury.
So we need to figure out Exhibit 29 and what was misfiring there. We also need to figure out the Excel spreadsheet, which is Defense Exhibit 8. We can do it in whatever order, but we're not breaking for the day until we get a little clarity as to each. Let's start with 29. It looks like
This
is really small. I saw March 25th, 2022. Is that the same one?
look at the book page number, 487 PG 506 509.
well, he was saying something about 222A.
Yeah, it's the second line says address 222 Fairburn Industrial Boulevard, Suite C, and Newer Rabai.
Well, that's identifying the location of the,
It's identifying the location of Rabai Investments LLC.
Okay, so that's not the property that's involved, that's the address of, okay, well, we didn't get to clear that up in a time that would have kept us here a little bit longer with the jury. But now we know everyone's got the same Exhibit 29. You'll just need to be able to direct the witness to, no, not the address of Rabai Investments, but what's the address of the piece of property that's involved. Okay, good.
Glasses along their arms to read this.
However you're gonna do it. We've cleared that up. What about Defense Exhibit 8? You can step down now, grab your cup.
oh, receiving that in discovery.
Have you looked at it, the online stuff? I mean, I sent y'all everything over the weekend, I mean, or last week.
Well,
And hold on, and those documents came out of the same share file where we produced the discovery. So I would have to look at the share file and show him, and I can't do it here, I want to log in at home.
Okay, so let's do that tonight. A project for the defense is to identify where in discovery, not exhibits that were produced this weekend, but discovery that was produced in a timely manner, where's that spreadsheet? Because Mr. Chambers is expressing a lack of familiarity with it. This is critical because Mr. Rabai has referenced it a number of times in a way saying, oh, that'll explain it. And if we look at this, we'll do that. So if you provided it, that's the plaintiff's going to need to navigate around it. If you didn't provide it, we're going to need to figure out what I tell the jury, especially if it's not coming in, about disregarding things about spreadsheet, or at least we just don't talk about the spreadsheet anymore. So
There's several spreadsheets.
okay, well, there's one that you've listed as Exhibit 8 on your index of documents. That one at a minimum needs to have been provided not as an exhibit, but unless it's some demonstrative, but it sounds like that's not it at all. Looking at these dates, it sounds like it's the Google sheet that morphed into an Excel sheet that Mr. Rabai was kind of treating as this is the Bible. This is going to have money in, money out.
I ask, is it anybody, identification number in the bottom?
No, the cell sheets don't. But when you provide the base stamp from the system I have, you won't get that within the cell sheet. You get the actual cell sheet. They show it that way. So all the cell sheets, I can show you in ShareFile where they are.
If you could do that this evening,
Yeah.
shoot an email or a text that says, look at, I don't know how you identify things within the share file, but however one does that, that will assist. I'll take that up with you all in the morning to see if the plaintiff's counsel is still saying, I didn't get it, and we'll process it accordingly. Anything else from plaintiffs? Do we have an update from Ms. Dyke?
I need to check my cell phone, Your Honor.
Okay.
Get it turned off.
All right, why don't you check that? Mr. Chambers, anything from you? No? Okay.
Unless the court's got a crutch.
No, but our hip patient that Mr. Fuller graciously struck, she had one. You just borrowed from her.
Actually, we may have the physical therapist on the board.
You have the neurophysical therapist. You do. The guy who had the bike fitting company.
While he's calling, can I, about logistics? and
Yes.
so on, what time can I get into this courtroom?
8:30?
Okay.
I have an unrelated question. Who's gonna be the on-duty attorney for, basically next Tuesday? For the primary runoff, and who's gonna be the on-duty attorney, would you know yet?
I'm not sure what you mean by, we have a presiding judge. I don't know about on-duty attorney.
No, I'm sorry, I didn't mean attorney, judge. Who's gonna be the?
Who is the presiding judge next week?
Yeah, is that how you're doing it? Cause it's weird. Like some counties, and I've seen that happen here in Fulton, where the judge will be like, well, Lonnie, do you wanna do it? And then no, it's their turn, but then someone else will do it.
Right, no, it should be, and the way it worked back on May 19th is that the presiding judge that week was the one who owned Tuesday. And so
Glanville.
that was Glanville. I don't know who, this is McAfee this week. I don't know who next week is, but I can find out.
Just curious.
Yeah, I'll let you know. It's not McBurney.
You're done with all that stuff, right?
I just don't have next week. All right, anything else? Or are we off the record?
I think I can be out.
We're done? Okay.
See,